Even in the case status, it is shown as posted on 9th of June.
Order sheet.
Beg your pardon?
The order sheet is reflected by 5th June.
Oh, okay. Because
maybe while uploading, maybe that you have to see the daily orders. In the daily orders, it is reflected there, list all.
daily orders is not posted also on the site, case status. Please check, it is not posted.
Whenever you want to verify the orders, you have to see the order, daily orders, because if any modifications or changes are there, it will be reflected in daily orders, not in the that uploading of our portal update.
I know that, ma'am. I'm an outstation. I'm coming from Delhi, but I've checked the daily orders. It was not posted on the site also. Anyway, I will make a submission. Can I make a submission at 10:30?
Make.
Thank you. Thank you.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಸರ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಆದ್ರೆ ಕೊಟ್ಬಿಡಿ ನಾವು ಕೊಡ್ತೀವಿ ನೀವು ಅಲ್ಲಿ ಫಾಲೋ ಅಪ್ ಮಾಡ್ಕೊಡ್ತೀವಿ ಅಷ್ಟೇ ಇವಾಗ ತಗೊಳ್ತೀರಾ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ತಗೊಳ್ಳಿ ಏನ್ ಸಬ್ಜೆಕ್ಟು ಏನ್ ಸ್ಟೇಜಲ್ಲಿ ಇದೆ ಇದು ಫ್ರೆಶ್
ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿದೆ ಮ್ಯಾಮ್ ಫೈಲ್ ಇಲ್ಲೇ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು ಟೈಮ್ ತಗೋಬೇಕು ಅಬ್ಜೆಕ್ಷನ್ಗೆ
ಎಲ್ಲಿದೆ ಫೈಲ್
ಇಲ್ಲಿದೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ
ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ
ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಮ್ಯಾಮ್ ಅದಕ್ಕೇನೆ ಲಿಸ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ ಫೈಲ್ ಪೆಂಡಿಂಗ್ ಅಲ್ಲೂ ಇಲ್ಲ ಸ್ಕ್ರೂಟ್ನಿಯಲ್ಲೂ ಇಲ್ಲ ಕಂಪ್ಲೇಂಟ್ಸ್ ಅಲ್ಲೂ ಇಲ್ಲ
ನಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಯಾವತ್ತು ಪೋಸ್ಟ್ ಆಗಿತ್ತಂತೆ ಇದು ನೋಡು ಸ್ಟೇಜ್ ಬಿಂದು ನಮ್ಮ ಹತ್ರ ಎಲ್ಲಿ ಇದೆ ಅಂತದಂತೆ ಅದೇನೆ ಫೈಲ್ಸ್ ಬಂದಿದೆಲ್ಲ ಹೋಗಿದೆ ಇವರ ನಮ್ಮನ್ನೇ ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ ಇದ್ರೆ ಇಟ್ಸ್ ನಾಟ್ ಪೋಸ್ಟೆಡ್ ಬಿಫೋರ್ ಅವರ್ ಕೋಡ್ ನಮ್ಮ ಹತ್ರ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು ಇಟ್ ಇಸ್ ನಾಟ್ ಪೋಸ್ಟೆಡ್ ಬಿಫೋರ್ ಅವರ್ ಕೋಡ್ CVS ಕೋಡ್ ಮುಂದೆ ಆಗಿದೆ
ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್ ಯಾರು ಇಟ್ಕೊಳ್ಳಲ್ಲ ನೀವು ಕೇಳಿ ನೋಡಿ ಅಲ್ಲಿ ಫಸ್ಟ್ ನೀವು ಬ್ರೇನ್ ಕೇಳಬೇಕು ನೋಡಿ ಯಾವತ್ತು ಪೋಸ್ಟ್ ಆಗಿರೋದು ಮಾಡಿದ್ರೆ ಕೈ ಸಿಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಫಸ್ಟ್ ಕೈಯಲ್ಲಿ ಉಳ್ಕೊಬಂದು ಅದೇ ಗೊತ್ತಿಲ್ಲ ಗೊತ್ತಿಲ್ಲ ಏನು ಮೇಡಮ್ ಅಲ್ಲ ಅದು ಅವರು ವಿಡ್ರಾವಲ್ ಅಂತೆ ನಾಳೆ ಕೊಡ್ತೀನಿ ನಾಳೆ ದಯವಿಟ್ಟು ಅಲ್ಲ ಎಕ್ಸಿಗೇಮ್
Successful.
Fresh matters ಎಲ್ಲ memos ಕೊಟ್ಬಿಡಿ sir. All fresh matters give the memos. ಇದೇನಿದೆ ಅದಾನ ಸಾಫ್ಟ್ವೇರ್ ಈ ತರ ಬರ್ತಿದೆ ವಿಂಡೋ ಏನೇನೋ ಚಿತ್ರ ಬರ್ತಾ ಇದೆ. ಏನಿದು ಅಲ್ಲ ಪುಸ್ತಕ ಹಾಕ್ಬೇಕು ಕೊಡ್ತೀನಿ ಇಷ್ಟುದಾ ಇಲ್ಲಿದೆ ನೋಡಿ ಏನದು ಹಾ ಅದೇ ಮೆಮೋನಾ ಸರಿ ಹಂಗೆ ಇಡಬೇಡಿ ಸ್ಪೇರ್ ಆಗಿ ಟ್ಯಾಗ್ ಪೋಕರ್ ಕೊಡ್ಲಾ ಪಾರ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಾ ಪಾರ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಾ ಅಂದೆ
Amy. May make a submission. Milord. Item number 57 in first list, Your Lordship. Am I audible, Milord? I'm not able to hear Your Lordship.
I will be calling page-wise adjournment, ma'am. Whenever page comes, you submit.
That's obliged. I'm sorry.
Page number 7, sale number 32 to 40.
Serial number 33, madam. 2 weeks. 2 weeks time may be granted.
Have you informed the other side?
No, madam. I will inform.
Ashok Kumar.
Wait. Please wait. Yes.
Page number 8, sale number 41 to 48. Page number 9, 49 to 50.
Serial number 49, my lord. Counsel for respondent, my lord. Finally 2 weeks adjournment.
Inform the other side.
I will inform.
Same thing applies to you also.
Page number 10, 57 to 59.
Your Lordship,
Milord,
serial number 52,
57.
Your Lordship. Serial number 52, I'm seeking accommodation of 3 weeks, Your Lordship. I've informed the other side as well. My senior is not keeping well. She met with an accident. Your Lordship, one more submission. There is a interim order in 52.1, Your Lordship. Much obliged.
57, Milord. I'm for the petitioner. Somehow it was
51. Why you want time?
Because the matter is settled before the family court. I have to get the certificate.
It is submitted that the matter is settled before the family court, and for filing the memo seeks 2 weeks time. List up 2 weeks. Yes, 57.
Yes, I appear for the petitioner, my lord. Somehow I'm coming from Delhi. There was some wrong posting of the case in the status showed as 9th of June, my lord. Therefore, I couldn't come today. I'm unwell. So may I come next week if possible? I'll inform Advocate Manjunath right away, who is appearing for the respondent. Maybe on 12th or after a week also.
Petition. Yes, next. Call the list.
59 withdrawal.
59 withdraw.
59.
Take that. The memo is filed stating that the petition has become infectious, hence seeking permission to withdraw. Accordingly, memo is taken on record. Yes, call the list.
List number 1, for dismissal, serial number 1.
Well, as list number 2, I'm sorry, madam. Disturbing my lords. Serial number 20. My colleague has a visa. Her daughter is my lord. Convocation in US. She has appointment at Mumbai for visa, my lord. She has requested for Monday, my lord. Only day, 2 days accommodation. My lord, my lord, 2 days, only 2 days accommodation. Monday, my lord. I am not asking more than.
Monday.
Please.
20 Monday.
Please.
Yes.
Sale number 1. Mahadev Swami P.
It's a paper petitioner, my lord. The 125 proceedings, my lord. The trial court has dismissed the petition, my lord.
Why were you not there yesterday?
My lord, yesterday I would come to late.
No, casually 2025 matter coming out for the first time. And you don't
For,
even represent.
Notice, my lord.
Yes.
The trial court has dismissed the claim petition on the ground that in the MC petition, permanent alimony was.
Notice to respondent.
Much
Released from dismissal.
Sale number
Yes.
2. Raghuram.
It's a fresh matter that came up before the court on 4/6/2025. There is no representation. As a matter was directed to be listed today for dismissal. Today also there is no representation. Accordingly dismissed for non-prosecution. Yes.
Till number 3,
And for the petitioners in all these matters,
Sebastian.
these 4 writ petitions which have been filed challenging the order of common orders on 8/4. However, in the first 2 matters, it said 3 and 3.1, the order on 17th of April was to list the matters on 10th, my lord. I've complied with the objections. Now, when I follow the website says, yes, I have complied with it. I have a printout. However, when a junior is checking on the app, it says no. There are 4 writ petitions. The last one is such. I'll serve a copy end of day today. He's come in, a lot. Learned friend has come in today. I'll serve a copy by day end or by tomorrow day end. I'll serve a copy on him. If any objections are, I'll comply with it. But I've complied with the first round of objections.
3.2 has become infructuous, my lord. 3.2 has become infructuous. 3.2.
I'll
It was
come back
only
to
for
that. Let me comply
summer
with
vacation, visitation
Yes,
for
it has
summer.
become
It has become infructuous now. 3.2.
anyhow. All the 4 matters are coming up, my lord. Let it be together and then we will decide later.
Does these matters on Monday? By the time the office objections, if any, shall be complied with.
Obliged.
Till number 4, Spurti Hegde.
Yesterday, my lord, I am withdrawing this as the 13B was filed and they have settled the matter in the vacation itself, my lord.
Yes, take that.
This is for challenging the maintenance award.
Seeking to withdraw the writ petition. Now, a memo is filed stating that the parties have settled the dispute by obtaining a mutual consent divorce and seeking permission to withdraw the petition accordingly. Dismissed as withdrawn memo
Much
is
obliged.
taken.
Till number 5,
Sorry, my lord. Yesterday, my lord, I was in another court.
Yes.
My lord, husband filed this
What are the
petition.
office objections?
Only, my lord, the interim order, my lord, IA number is not given before the trial court. And so I could not able to mention the details of the IA, my lord. Officers raised objection to mention the details of IA number.
IA details to be stated at prayer. Come to the impugned order.
Please,
They passed it in the MC itself.
annexure E, my lord. Yes.
Page number.
Page number 61. Lord, this case, my lord, the 20,000 interim order, interim maintenance has been granted by the court below.
The office objections with regard to mentioning of the IA number is overruled. As in the order also, the order is silent with regard to the IA. Yes,
Plus 20,000 interim maintenance was granted by the court below, my lord.
to the wife or the children.
Wife and children, my lord.
How many?
2 my lords. Wife and 1 children, 1 daughter.
So
Plus
10,000.
what happens, my lord, in the meantime, there was a several negotiation was taken place.
No, before that, what is your income?
Plus I am agriculturist, I have agricultural land. Plus wife and my sisters, both are filed suit for partition. In the said partition, I have got 1/4 share, my lord. My daughter also got a share in the my lord's family properties. Plus except the agricultural income, there is no other
Let's
agricultural
see what is
income.
the finding of the court on this.
Please, plus no, my lord, regarding income, no finding recorded by the court below. The court records the finding only that, my lord, I have the agricultural lands, my lord. As you kindly see the page number 63, my lord, reasons, point number 1. I have gone through the case
Pay
paper.
half of it, we'll see.
May I make one submission? My lord, the court bill is already ordered for, my lord, proclamation to attach the, my lord, my agricultural land. What is the my share is already at.
Stay will be granted on that condition. Stay will be granted on the condition of paying 10,000 per month and arrears also at 10,000.
I could not able to, my lord, pay that much also amount, my lord,
Even
because
half of the amount also. How can you get
I
away
request,
without
my lord,
paying?
only, my lord, 25% amount. My lord, parties are, my lord, every day, my lord, conciliation.
Then gone through for the trial court, the family court, by order impugned and granted maintenance of an amount of rupees 20,000. It is submitted that the petitioner is an agriculturist and the court has not given any finding with regard to the income of the husband, income of the petitioner herein, and without any basis had granted maintenance at 20,000 and is not in a position to pay, considering the submission. They shall bestow of all further proceedings on the condition that you shall pay 10,000 by 5th of every succeeding month, and the arrears 25% of the arrears within 8 weeks.
Please, oblige.
Default order.
Then number 6. N. Suresh
Delete
Babu.
from dismissal. Your cases are represented. Delete from dismissal.
Then number 6. N. Suresh Babu. Non-furnishing of power acknowledgement.
For dismissal tomorrow.
Then number 7.
Dismissal.
For the petitioner, my lord. We are seeking a review of the order dated 25/3/2024, which was passed in WP 5062 of 19. The same judgment was passed by my lordship. There are certain aspects that was inadvertently missed out in the judgment. We are seeking a review with respect to those aspects, my lord. On the last occasion, my lord was pleased to issue notice, but the respondent has long left that address which is furnished by her, and we seek permission of the court to issue the notice to alternative addresses and also through WhatsApp and email. And there
Let's
is,
see the order first. Come to the order.
my lord,
Come to the order. Where is the order?
my lord, please, if you may peruse page number 25, annexure A.
Yes.
My lord, during the continuance of the proceedings in WP 5062, that
No.
time the respond,
Please tell the court what are the grounds for review.
yes, indeed, my lord. My lord, our first major ground is that the respondent is not residing in the scheduled property. She is illegally occupying the ground floor of the petitioner's property. She has put it under lock and key. She is not allowing him access. He's losing out on rent. He's not able to repair and all. Indeed, there was an order in the WP itself, my lord, that she has to vacate. Even the police protection was asked for. But even after all that, she did not vacate it. She has not delivered the key. So specific orders have to be passed in this regard, my lord, because she has a long history of evading court compliance, and also she is evading a process also, my lord. That is one ground, my lord. And then also, my lord, if you may peruse annexure C, which is at page number 46, my lord. I have produced the memo of undertaking that has been given by both the parties. During the continuance of the WP, both the parties had given memo of undertaking stating that they will withdraw all the complaints and cases filed against each other. With respect to that, my lord had passed the impugned judgment. But my lord, specific orders were not directed for withdrawing all the orders, and that's why the matters are even continuing even now, my lord. So we are requesting for modification with respect to this aspect also. The third thing is, my lord, we have to fix a proper time frame from when to when the rent amount has to be paid. So in the order, those specific dates are missing, my lord. Inadvertently, it has been missed. So we are seeking modification with respect to that also, my lord. These are our main.
Those are all the grounds for review.
Indeed, my lord. My lord, right now I am seeking permission of the court to issue notice on alternative addresses, my lord.
What are the alternative addresses?
My lord, I have a address where of her father and uncle, my lord. So I may be permitted to serve there.
What happened to the first time notice?
My lord, the address given by her. She is not residing there, my lord. She has long vacated.
Asking what happened to the notice.
It is on
Only says door locked.
Indeed, my lord, because she is only put
Try
it
for the
on lock.
second time. The procedural,
My lord, may I please be permitted to issue through WhatsApp and email, my lord?
it will be done within a week. We'll see.
My lord, I have address of her counsel in a connected matter, my lord. May I please be permitted to give to the counsel?
Connected matter.
My lord, in WP 10452 of 2025, that is the advocate Arvind Negnur is the counsel. WP 10452 of 2025.
Is it pending?
Indeed, my lord.
Then counsel for the petitioner is permitted to take out notice on the counsel appearing with respondent in WP number 10452 of 2025 and file a memo to that effect. If the memo is filed, once a memo is filed, is the matter.
Cell number 8.
Internet.
Cell
Much
number
obliged.
Appear for the petition, appears for 110.
It's a week's time.
Much obliged.
Default order.
Cell number 9.
Let's say steps are taken 24 for 2025. I have take steps, my lord.
You have paid the process.
Okay.
It is submitted that the needful is done. This is matter to service of notice. Yes, 10.
Cell number 10. Srinivas. Shivarama.
I represent the petitioner in this case. I will withdraw the petition because of the office has raised the objection that the petition
Office
is.
has raised an objection with regard to the maintainability. As a RPSC is filed against an interlocutory order, office objections and the petition is dismissed with the liberty to file a appropriate petition.
May directed to the office to return the certificate.
Appropriate petition within a period of 15 days.
Cell
The
number
office is
11.
directed to return all the documents.
11. Baire Gowda.
An award of 7,000 has been awarded by the family court.
Hmm.
An interim stay granted subject to deposit of 5,000 per month. They have to produce an acknowledgement having paid the amount.
Verify, produce the acclement and next day. Next week, 2 weeks time.
Why 2 weeks? When is this order passed? On 26/2/2024.
Yes,
And
sir.
1.5 years.
Has they paid the amount or not? Not even a single pie.
I will verify and submission.
No verification. What verification is required? If you have paid, you would know. Or if you pay, if your client has paid, you would have, because the matter is listed, you would have
Next week,
taken instructions. Not tomorrow.
Tomorrow, next. Day after.
Tomorrow. If the amount is not paid, I'll vacate the stay, and I'll also make it clear
Okay,
that
next Tuesday will also. Next Tuesday will also.
yes, Tuesday.
Next.
List this matter on Tuesday. By the time the land calls for the petitioner shall submit whether the interim order is complied with or not, or else the stay will be vacated.
Some
Cell number
submission,
12.
the Wednesday also, not Tuesday, Wednesday.
Wednesday.
Good.
Cell number 12.
Lord's petitioner. Lords, may I request this to be tagged along with WP3 5544, my lords, which is the respondent's petition. She has filed and a stay has been granted or conditional stay.
Along with so and so.
WP 3.
35544 of 24, my lords.
Yes. Next.
Great.
Cell number 12. 13.
Appealing for the petitioner, my lord.
Prasad.
My lord, the matter is settled out of court in the trial court. So hence the petition may be dismissed as withdrawn.
That the main MC is settled.
MC.
Main MC itself is settled before the family court, and no further orders. And this petition has become infructuous. Dismissed as infructuous. Yes, 14.
Cell number 14.
Petitioner, my counsel submission, my trial court is minor is a party, my D&W, not required, my this petition not mentioned. That only that is objection raised by this petition. Yeah, only for mandamus is my.
Counsel for the petition has partly complied with the offer of petition. Minus a amended petition, not made party, not showing in cost title to be clarified.
Trial court already filed the application, delete the minors, also.
Why you will not make him a party?
Not required, because he's a minor, trial court.
So why is he made a party? Is he made a party before the trial court?
Minor guardian is father is a party.
Should reflect the cost title. The office objections are sustained. The petition shall comply with the office objections.
Date may fix.
A week's time is granted. Once the office objections, or whenever the office objections are cleared, list the matter immediately. Yes.
Number 15. Kapil Dikshit.
My lord, for the petitioners, my lord, 1 week time may be granted, my lord, to comply with the officer.
Week's time.
Much obliged.
Number 16.
Here for petition, my lord. My lord, index is overwrite, my lord, except that all the objection is compliant, my lord. Index is overwrite agide another split.
Have to do it. Whatever.
Day of the course of the day.
A week's time.
My lord, course of the day, 2:30.
It is submitted that the council will comply with the office objections during the course of the day. If it is complied with, list the matter on Monday.
Monday out of station, my lord, please.
Huh?
Monday out of station, my lord, 10th, please.
10th.
Oblige.
Cell number 17. Bhargavi Dev.
The petition in this matter, Lord, have complied with all of the office objections except objection number 6, which is certain better copies of certain pages.
Let's see what is that.
My Lord,
better copy of page number so and so to be filed.
Those are IT returns that the respondent filed along with his affidavit, which I have to, that is the best copy that he has given me. I have filed that.
You will file the typed copies of the same.
In 4 weeks, I'll file typed copies, my lord. In the meantime, my lord, if I may be permitted to
Let's
just,
see, what are all our tax returns only?
only tax returns and some bank account statements, which at the end, he's admitted what is his income. The order also accepts his income as well as his expenses. If I can convince my
Office
lord.
objection. Regard to filing with a better copy of page numbers 150, 153, 154, 158, 159, 177, 182, 183, 184, 185. Then counsel the petitioner submits that within a period of 4 weeks. He'll file the typed copy of the same, considering the office objections or overruled for the present. Yes.
Good. Lord, may I take my lord through the, my lord, the petitioner is the wife. The marriage of the year 2002.
What
they
is
have a
question
son.
now?
My lord,
What is question now?
the maintenance, award of maintenance of only 20,000 rupees in favor of the wife. My lord, seeking enhancement.
Notice.
The only thing is, I have sought for interim
No.
grant of,
Notice.
Cell number
my lord,
18.
may seek permission to serve the counsel appearing for the respondent
Counsel,
before
the
the trial.
petition is permitted to take out and summons from the counsel appearing for the respondent and shall file a memo to that effect.
And may I seek a date be fixed, my lord?
Once the memo is filed, is the matter.
Grateful, my lord.
Cell number 18. Venkatesh Somareddy.
Wait,
Office objections?
that has been paid about the court fees. We instructed it has been paid.
No. Annexure F and F1 date not forthcoming. That's objection.
That your lords may kindly permit the dates F and F1.
I will comply with the officer.
In the course,
During the course of the day, I will comply with the officer.
F and F1, my lords. That's about the interim maintenance.
Above appearance.
Please, interim maintenance. that
Above
has-
appearance for the respondent.
File it before
Yes,
the
we'll file
registry.
it.
Under section 24, my lords, out of 15,000 to order to be paid
Wife is before the court.
for the
No, who is before the court?
husband is before the court challenging the order of interim maintenance.
How much is granted?
15,000. Contention is, my lord, she herself admits she is employed. Her income is 26,800 as per her own admission.
And
She's-
what is the income of the husband?
Husband is income is 77,000 per month. One aspect is, my lord, she residing now along with her parents, according to her statement. The interim, to the extent she is not able to maintain herself. 26,800 is her income, and plus she has shares which she has herself mentioned, value of which is 1 crore 2 lakhs 554. Sorry, 1 lakh 2,554. This is her own statement in the assets and liabilities. So when she has income at the interim stage, my lords, when she has the income to sustain herself, and saddling.
No, out of his 77,500.
Please.
If you pay 15,000 to the wife, still he is left with how much? He is left
No, my
with
lord,
another
he's,
60,000.
one aspect is, no, my lords, I do bow down, my lord, one aspect is that, but may I submit, my lords, that he has his liabilities, his parents, and loan, etc. My submission is, my lord, to the extent she is not capable of taking care of herself. That's section 24, my lords. When she is.
Your Honor, she has to take care of not just herself, her parents also. Your Honor, 498A case also is pending, Your Honor. She was brutally thrown out of the house, Your Honor.
Both are pension.
Hence, the case is still pending, Your Honor. 15,000 is way less when compared to the amount of marriage expense, amount of so many things that was done by the women, Your Honor. She suffered so much. That's why she's before the court, Your Honor. 15,000 is nothing. He's a bank manager, Your Honor. Earning enough, Your Honor.
Both were government servants' parents, pensioners. Both of them are pensioners.
Then you also have no responsibility to take care of the parents.
My parents are not pensioners. They're at home. I'm taking care of. Her parents are pensioners.
But he himself
independent
decided
house.
to throw his own wife out of the house, Your Honor. The case is still pending.
No, my lords, the criminal case was stayed on the ground that this criminal case was initiated after we issued a
Your Honor,
notice.
only from A1 it is not stayed, Your Honor. A2 or not only.
Yes.
Now the ground, my lords, now at this stage, my lords, whether she has sufficient income to maintain herself or not. And in her application initially, she does not mention about anything about the income.
But there are other line of judgment saying that the standard of living
Please,
what she
please.
was having earlier should also be maintained.
Please, my lord. No, my lord, she lived only for 6 months with the husband, left her on her own.
But still,
No,
the
my lord, I don't
interpretation
come
to
to that.
is
My lord,
very much enlarged in the interpretation.
I do consider this is a case, my lords, where if I can remind myself, my lord's words, which is widely circulated, that she, when she's capable, she should earn. And here is a case where she's capable, she's earning, and 26,800 the monthly income she's getting. And just simply filing an application, suppressing everything. When we came out and said that she's earning, then now she comes and says, yes, 26,800 is earning. And it's bona fides also. In the application, nothing is mentioned.
There's
It
no
was not a case
separation, yeah.
urgently to grant immediately, my lords. Therefore, this is a case where your lords may kindly consider this application, my lords, and stay the operation. Payment of 26,000. This is not a case where she doesn't have any income, my lords.
No, it is now both of you are here, nothing to
Yes.
say. We can stay,
Yes,
maybe we
yeah.
can decide this
Please,
application
please,
on-
please, I bow down, my lords. I bow down.
Your Honor, I would like to file objection. I have not received.
You give her, serve her the copy, and
Please.
then we'll take it up on Tuesday.
Yes,
This on Tuesday.
Please, please, please.
Name record.
So and so submits that. She has instructions to file wakalat. This is the matter, and counsel the petitioner shall serve the copy of the petition to the counsel for the respondent. List it on Tuesday.
Yes. Still number 19.
I'm grateful.
19.
And office objections to be
I will-
complied with during the
During the
course of the day. Yes.
Please.
Still number 19. Nildur guest, Vijay Kumar.
No representation for dismissal tomorrow.
Still number 20.
Appear for the petitioner, my lords. My lords, the short case here is the child was born on
What is
31st.
this rectification of office objection?
Office objections have been complied.
Then why is it there on the?
I went to the office yesterday and I had compliance. They said it has been corrected. And that's why it was not listed, because I moved a memo before your lordships yesterday.
Where is the respondent counsel? What is happening to them? Where is the respondent counsel? It's coming up for the first time. I think they've completely stopped using any common sense. Find out who is this, who has done this. Yes, give the file. Yes, what are these petitions?
My lord, so the child was born on 31st of August 2022.
No, first tell the court. WP 14353 is, what is the impugned order in there?
Annexure E, common order dated 23/4/2025.
Yes. Come to the operative portion of the order.
Yes. May I read the operative portion?
Yes.
IA number 3 under section 12 of the Guardians in Wards Act 1890 read with section 151 of the CPC filed by the petitioner is partly allowed. IA number 4 under section 12 of the GNW Act read with section 151 of the CPC filed by the petitioner is partly allowed. Petitioner father is entitled for interim custody of the minor child Rhythm MS between 2 p.m. to 6 p.m. on every Saturday and Sunday, and he shall pick up.
What is your grievance now?
Now, the grievance is, prior to the passing of this order, custody was on an interim arrangement discussed by the petitioner and respondent here, and there was no concrete interim order regarding how custody will be shared. It was discussed between the petitioner and respondent. Now, the problem here is the petitioner, that is the husband, has only 4 hours of custody every week.
This is by the father or the mother?
I represent the father. Petitioner.
Let's issue notice in this.
This has to be read with the second petition that was passed, because petition number 14361. So in that, on IA number 2 and 8, a common order was passed, dated on the same day, 23/4/2025. There, if your lordships will come to the operative portion of that petition.
In this, we'll order notice. Notice to the respondents. Yes. Or if you want to take a notice on the council, you can take.
Yeah.
In the first matter, a petition is permitted to take notice of the
Your
council.
lordship, if you can approach the operative portion of IA number 2 and 8, common order. IA number 2 under section 9 and 12 of the Act, read with order 39 rules 1 and 2 is allowed in part. Respondent is hereby restrained from removing the minor son Rhythm from the territorial jurisdiction of Karnataka without prior permission of this court. So the genesis of this order starts from IA number 2, where the petitioner father sought to restrain the respondent from taking the child out of Bangalore, given the dire medical needs of the child. The medical needs of the child are dire because he suffers from a congenital disorder known as vesico-ureteric junction obstruction, where medication and constant care is constantly required. And this is a case of super specialty care that is required. The respondent's maternal house is in Hubli, resides in Hubli. So she visits frequently. We had no problem taking the child to Hubli prior to the passing of this order. What happened in the interim is, Your Lordship, because we had prayed to restrain her from taking the minor child out of Bangalore. She filed objections to IA number 2. Also, 1 year later, it took more than 1 year, and then another IA was filed, IA number 8 in 2024, stating to vacate IA number 2, despite filing objections for the same prior. And then we filed objections on the very next day, once we received the order.
How you agreed with this? I'm not able to understand.
Sorry?
What is the difficulty with this order?
The prayer in IA number 8 was that she can take the child to Hubli. And the court has granted permission to take the minor child all across Karnataka. And it makes the order in IA number 3 and 4 unimplementable. Because there is no prior notice required by the respondent to say, I am taking the minor child here and so on and so forth. Because here prior information is required in petition number 14353. But in this case, the respondent is not required.
There is an order of visitation for you. She has to comply with it.
Yes.
And whenever in between, when you're not having the visitation, she is at liberty to go anywhere. What is your difficulty?
Because in this very same petition in 14353, I am asked to pick up the child, wherever that child might be. Now, without prior...
Child might be, where is that order that wherever the child might be?
No, because there is no prior intimation that the child has to be picked up from the mother's residence in Bangalore.
That can be clarified. It's a very simple case. You take notice.
Well, that's because there is no prayer for the same effect, and the relief has been granted.
Pertaining to the child and the order that is passed, there is no prejudice caused to the father. What is the prejudice? Why? Because the custody matter is pending. She can't even go to her house at Hubli.
The mother has not been providing the requisite medicine to the minor child frequently, or even
different aspect. That's a different aspect.
The welfare of the child is being hampered, my lords.
Correct. Where is the application for that? There is no application in that regard. That proper medication or proper treatment is not provided. Now you say that whenever she goes to wherever within the Karnataka jurisdiction, your visitation will be affected. If that is the case, we'll clarify that.
And it's not just the visitation aspect, if I may make a submission, because this is the medical needs of the child.
Can you say that about the treatment and all? That has to be, there needs to be an adjudication on that. Just like that, you cannot say.
The treatment has the only place in Karnataka, and not just Karnataka, in South India. Even people from abroad visit as the Narayana Health Group in Electronic City, where the child is being treated for a super specialist.
Everything can't be decided in this application as far as this order is concerned. This court do not find any reasons to interfere. And what is your apprehension is about your visitation? To that extent, we can clarify, provided the mother is here. Take the note in this also same notice.
Cell number 21.
Yes.
Anil R. 21 Anil R.
No representation for dismissal tomorrow.
Cell number 22.
As I'm praying for the petitioners in this matter, my lords. File this matter for restoration of the matrimonial proceeding that I had.
What is this non-compliance of office objections?
I will comply with it, my lords.
Comply.
At the earliest, when
office objection shall be complied. When you will comply?
In 2 days' time, my lords.
With 2 days' time is granted for complying with the office objections, default order. If the office objections are complied with, this is a matter immediately.
My lords, can the notice be served? Can be issued, my lords? In the meantime, I'll comply with
you want notice?
Please,
you have to comply with all these objections.
I will comply with it, my lords.
Once the office objections are complied with, notice to the respondent. Yes, list after service of notice.
Great.
Next, 23.
Cell number 23. Pranav Venkat Vishwanath.
No representation for this.
I apologize, my lords. This is I was for 23 minutes.
Not 22.
I apologize.
22 for dismissal, same order in 23. Yes.
Cell number hearing on interlocutory application. Cell number 24. 24. Pramodar.
No representation for dismissal.
Cell number 25. Jayana.
The delay is 400 days, madam.
My lordship, as order dated, my lordship, 14th October 2024, 14/10/2024, my lord. This court is passed an order. He has to pay the amount of rupees 50,000 on 22/10/2024. Further sum of rupees 60,000 on or before 15/10/2024. Till date, he has not complied, my lordship.
My lord, it is entirely
And,
complied, my
second,
lord. Before
after
the
that, my
trial
lordship-
court, the petition is closed, my lord. There is an order, my lord. Because trial court issued coercive steps, my lord, complied, my lord, entire thing, my lord.
Give it to him
My lordship, another one submission, my lord.
tomorrow
Tomorrow.
My lord,
at the request of non-counsel respondent. Look at it,
Cell
look
number.
at the,
Okay. Cell number 26.
my lord, delay may be condoned. Delay may be condoned.
tomorrow we'll issue final orders.
Please, ma'am.
26. Mushrat Tabsam.
Appearing for petitioner in this matter, madam.
Umesh BN.
376 delay in filing the petition, madam.
Objections are filed?
Madam?
Objections are
No,
filed
madam.
to the
They
IA?
have not filed the objections.
No representation for the petitioner. Respondent, and counsel the petition is present. This is matter tomorrow. Tomorrow also he doesn't turn up, we'll condone the
Please,
delay.
madam.
Number 27. M. Veerbhadraya.
I'm appealing for the petition. Kindly pass over the matter, my lord.
No password.
My lord, in this matter, my lord, there is an interim order, my lord. We have filed IA for IA 1 of 2025 for direction, seeking direction. Yes, seeking direction, my lord. My lord, direction is, my lord, my lord, this writ petition is filed, my lord, challenge.
Asking for a password.
Yes, obliged.
We'll take it up tomorrow. This is matter tomorrow.
Obliged.
Cell number 28.
Petitioner. Lord, the report that was submitted yesterday, we had a chance to go through it. But insofar as the annexures that goes on up to 40 pages, it would not be practical for either one of us to actually take a note of all 40 pages. I've taken my notes.
Those are all not to be, no need to go through all that.
The reason why it has to be gone through is for the reason that they have stated specifically that there is a need for admission of the child for a span of 4 to 6 weeks. And I do not see in the report as to any scientific backing for need for 4 to 6
So I
weeks.
think sitting here, neither you nor the court
Yes, ma'am.
can decide about the requirement, competency or otherwise of the doctors. And you cannot submit nor I can decide that whether the doctors are right or wrong.
But the doctors have to state by way of,
Do you think that what would be the reason for the doctors to pass?
that is what they have to state in the report. For example,
We have stated
insofar as, if I may, my friend, insofar as the doctor having giving an opinion insofar as whether there is a requirement of admission or not, he is supposed to give some scientific backing to it. That is the guidelines. That is how the law is established. And insofar as admissions are concerned, there is an entire different law for that. No doctor could come forward and submit a report. Insofar as the report that he has submitted also, if my lord, one more point that I would like to very specifically state, the admissions that they have done from 5 to 8, that was not the order of this court. This court did not pass an order directing them to admit the child or the mother in the hospital from a span of from 5th to 8th. Insofar as they have stated, if my lord, insofar as the report that they have given very clearly indicates that on 8th when the mother had to get out from the hospital.
Your client wants it to be. What she wants? Like she'll keep her in the house?
No, that's not the point. From day one, we were stating that insofar as the child's best interest is concerned, it is required that the father and mother, in fact, I proposed it, that the father and mother both along with the child, let them attend counseling or let them go to the counselor, let them go to a child psychiatrist. Let that be done.
According to your client, that is the treatment.
There is no need of treatment. The word treatment itself is wrong.
You don't have to shout.
Yes, madam.
Switch off that mic. Or you're audible to me.
Yes.
So, according what your client suggests, what is the mode of treatment? How the
But
child
the word
has-
treatment itself is wrong.
Whatever it is, the counseling or whatever,
Yes.
according to whatever you say, whatever word you want me to use, I'll use.
No, treatment. The problem here is insofar as when we go with the idea of treatment, there has to be an illness. Insofar as now when the reports are given, it is mandatorily by way of law that when a doctor states that somebody has to be admitted in the hospital for whatsoever purposes, insofar as the Mental Health Act very clearly states, only when illnesses are there, such an admission can be made. So
Now,
when I
according to you-
am objecting the report,
According to you, she is not mentally ill.
not according to me, my lord, according to the doctor also, she is not mentally ill. Not according to me. That is exactly why I said, my lord, I need the copies of those 40-page documents in order to make further submissions on that. With a single page document, it is not possible. In fact, the report that they've given, they should have made a cumulative
So
report.
like this, now with that the girl is not interested to meet the father. With this, with all these kind of whatever steps, you will take it forever, and girl will never meet the father.
Absolutely not, madam. That is
Then-
what I proposed from day one. I said, let the father. The issue here is, if we would have gone through the documents, my lord, it very clearly indicates that the child was in the registrar's office. The child was directed to meet with the father. The child was sitting there. The father was there. The grandmother was there. All of them were there. They sat the entire day there. Then comes the next day. After 2 days of continuous efforts that is put across by the court, by the father, by the members who were present, the judicial officers, the child did not want to talk. I am saying that is wrong. The child should be talking.
And
I am
what
not in
is the
support of the child not
contribution from the mother?
sorry.
Please, I understand, but the court query you understand and answer it will say, it will.
Right.
Yes. I am asking you, what is the mother doing towards this?
What should be the mother doing, madam?
You can't. I'm asking you.
No,
You cannot.
insofar as
you
I am
can't-
concerned,
You can't
no, madam,
question
insofar as
what
I am
they should
concerned,
do.
the reason this question I am putting, it is a rhetorical question, madam. The reason I am putting this question is for the reason that, insofar as the mother is concerned, the mother has brought the child here, the mother has told the child to talk to the parent, the father, the mother has done all of those efforts. The child is not talking for the reason which is already stated in our affidavits. If the child has faced certain, if the child has faced certain scenarios and the child does not want to talk, what can be done? What needs to be done is that the father, mother, and the child should go to the counselor. The counselor, who is a neutral party, should be able to tell the child, should be able to make the child understand. Without that, admission is not the process. Therefore, the report that they have submitted, I want to file a detailed objection on the report. In fact, on the previous report that they had filed, I have filed a detailed objection. Insofar as this is also concerned, I intend to file an objection to that effect.
May I make very brief submissions? Yes. To the extent of saying that a one-page report is not enough, I need time to examine the 40 pages. I sat, your leadership, after this court granted me permission to inspect the report. Before this honorable court, I sat 15 minutes. It took me to read the report. What I found relevant, I've noted down, and I'll just summarize that for this honorable court. On the first page of the report, it says, the reasons for requiring inpatient treatment. Now, this is a statement coming from the head of the department. And as your leadership rightly said, it is neither the father, neither the mother as parents, me as the non-custodial, him as the and her as the custodial parent. And with the greatest respect, this honorable court, none of us have as much expertise in dealing with this issue as the child specialist who has given this report. So to say that the mother's opinion on what treatment should be or what kind of counseling should be carried out in substitution of what an expert says, I think is untenable, respectfully. They say on the first page that the reason we want to carry out inpatient treatment is to understand the child's family history, to understand her mental background, to understand her psychological background, to recommend and carry out the best form of prescriptive therapy, and to most importantly and crucially understand the instances and the existence of whether she has been alienated by a parent towards another parent, parental alienation. This is a judicially recognized concept. They want to understand if it has been done, if it has been done, to what extent it has been done. At page 3, now this is a matter that she now disputes, but the report says on page 3, the mother has agreed for inpatient care. At page 15, a detailed evaluation is provided where the child in isolation from the mother is asked a few questions. Have you been threatened with violence by any parent? She says none. Have you been subjected to verbal abuse? She says no. Have you been subjected to actual physical violence? She says no. Have you been subjected to sexual abuse? She says no. These are questions that have been asked to the child in isolation during the 5th to the 7th when she was in examination. And that's what's happened over there. She has admitted to saying nothing. Or at page 18, the doctor records, it is only the mother who has made an allegation against the father that the father had exposed the child to himself in the nude at some point by mistake, and the father has a rage and anger problem. At page 22, again it's recorded, then when the mother is interviewed separately, she makes this allegation. When the child is interviewed separately, no allegations are made. At page 23, this is important. Now, we have to keep in mind the conspectus of facts. At the first instance, the mother leaves the matrimonial home. She begins the alienation of the child from the parental family. Then she appoints counsel to deal with this litigation. That first counsel is removed, and I would like to say alienated. Now she goes to the doctor at the instance of this honorable court's direction because she does not want to send the child to me. And she says that, and the doctor records, the mother has gotten angry and upset with the treating team. So she wants to alienate the doctors also. At the end of the day, it seems to me, and I say this with the greatest respect, that the mother neither wants to have the father interact with the daughter. She neither wants to comply with orders of this court for visitation. She neither wants to allow the child to undergo counseling and therapy at a nationally recognized, neutral expert facility. At the end of the day, what is wanted is, I will decide how the child will behave. I will decide who she interacts with, even if a judicial authority and a psychiatric evaluation says otherwise and says that I may not be in the right frame of mind, I may not be the fittest person to make these decisions. Your ladyship has observed that if the behavior of the mother continues as is, the court may be constrained to make an observation that she is not fit to take care of the child. Now the psychiatrist is saying that let the child be examined. The psychiatrist is not saying that there's a mental illness, but the psychiatrist says that upon having interacted with the child for 3 days, we feel the need that to fully understand what is happening and what has gone wrong, she needs to be admitted as an inpatient. The most important part, page 32. At every day's recording, where the child, she was admitted as an inpatient for 3 days, 5th, 6th, and 7th. 6 a.m. and 9 a.m. and 6 p.m. again, they record how the child is faring physically in the facility. And they say, child has slept well, child is comfortable. So if the child has, during the examination and evaluation at NIMHANS, not complained of physical abuse by the father, verbal abuse, sexual abuse, not been any allegations whatsoever, and she has rested comfortably in that facility for 3 days, the mother is the one who has made the allegations. The mother is the one who has fought with the treating team and got the child removed. The only explanation that the doctors reasonably can give to requiring inpatient treatment is, if nothing is wrong with the child, give us more time to figure out what might be the problem. And that's what they are saying. And that's what, respectfully, your ladyship, ought to be the direction passed. How do we substitute our judgment as non-experts for someone who's been doing this as a career? And someone who's looking at it through a non-antagonistic, neutral perspective.
Yes.
Friend, what you said is right. If nothing is wrong, give us some time to find something wrong. What I do not want. There's nothing wrong. For admission, there has to be something wrong that is found. That is the law. That is the law that the doctors are supposed to follow.
Where is that law? Where is that law, show?
So far as the report that is submitted, page number 30.
No, first you show the law.
I'm going to that. The report itself says, patient's guidelines for inpatient care, page 30, in the report that is submitted.
Yes. Give the report.
The report.
Yes.
I believe the first or second point in page number 30.
In page number?
30.
In
the report that is. Nowhere in all of that guidelines it states that in order to identify we need an admission. All of that speaks that an inpatient care is required only when there is mental illness. The word very specifically says. Also, Mental Health Act very specifically states only when mental illness is there can there be an admission, that is section 89 and section 90 of the.
Take that. Yes.
Admission and treatment of persons with mental illness with high support needs in mental health establishments. Then comes 19 about admission and treatment of persons with mental illness with high support needs in mental health establishment beyond 30 days. Supported admission beyond 30 days. I don't see a law, my lord, which specifically states that.
But you are assertively saying that. You are assertively saying that there is a law on this.
That the law is only when there is illness that they can be admitted. That is the law. Insofar as when there is no illness, they cannot be admitted. Is the established procedure as well. First and foremost. Most of the
If that was the logic, your ladyship.
No, let's understand.
Yes. Rehab centers would not be in business.
Let's understand.
Very
rehab center, somebody has to be identified as an alcoholic to be put in the
No,
rehab
you
center
can
for
address
alcohol.
the court, Mr. Counsel. You can address the court.
What I am pressing upon. We have one copy.
Yes. What is that you're addressing upon?
The medical guidelines. Anything that a doctor writes has to be supported by the internationally accepted standards. Insofar as anything that a doctor writes, it has to be supported by something that there has to be a reference to what he writes. It cannot be that, my lord, I come to this court and I say that I'm a lawyer. I've seen so many cases. Supreme Court in XYZ case said that I am supposed to identify and say that this is the law. How my lord is asking me at this point of time, what is the law? Insofar as anything that a doctor recommends, anything that a doctor writes, he has to refer, specifically when he's putting across such a point in the report. He cannot say that it is my opinion. Each doctor has, in fact, in that report that I submitted in the guidelines, number 40 very specifically states, he is also supposed to state as to the margin of error insofar as his opinion is concerned. Now, in fact, in what we have been submitted in this report, all he says is it is my opinion to understand this. If we look at the order that was passed, what was he directed to evaluate? He was not directed to evaluate any of these factors. He was supposed to evaluate. According to his evaluation, he has already stated that there is no problem with the child. Then why the admission? So I am only against the admission, nothing else. Let there be an evaluation insofar as to understand why the child does not want to speak to the father. That effect, there has to be an evaluation. But insofar as admission is concerned, that cannot be done. Because if it is permitted, then in every other case where there is an issue that comes up insofar as any person for that matter, then that becomes the norm of admissions becomes the norm. That cannot be permitted at all. So that effect is not.
Yes.
Just 2 points. Number one, your ladyship. A doctor who is the head of the department at NIMHANS would not irresponsibly make an opinion as to admit a 10-year-old child for inpatient care. To that extent, this honorable court ought to give deference to the clinical opinion coming from the expert. Had that opinion not been sought by this honorable court, we would not be here. The second, your ladyship, only as a riposte to the last point made, that if this is permitted, then law would become this. This is not every case. This is one of those extreme cases, as your ladyship has seen, where a warrant has come to be issued for a mother to comply with orders of visitation. It does not happen very often. It's not happened in any other case that I've handled. So to that extent, your ladyship, I just want to submit that the material that is required for this honorable court to pass a reasoned order basis the report is already there. It is neither my expertise nor, with due respect, my friend's expertise that can overtake the doctor's. So to that end, your leadership, I would request that whatever the findings of the report are, be considered while whatever orders has to be passed.
Please come. The writ petition is filed with the father, questioning the order passed in I number 3 and 4 in GNWC number 68 of 2023, dated 10th November 2023, whereby the court had permitted the father to visit the girl child every fortnight between 9 a.m. to 11 a.m. in the place convenient to the father under the strict supervision and monitor of respondent mother until final disposal of the case, and also permitted for a video call between 9 a.m. to 10 a.m. And the father's request for interim custody of the child is rejected. This is a case where, in spite of several orders that have been passed, and at every stage there was a disobedience of the orders of the court, and mother had shown scant respect to the orders of the court. Initially, a coordinate bench of this court is that order, which is the date of the order of Justice Erur,
Your Ladyship, that is 21-3.
21?
21-3. Sorry, 1 second, Your Ladyship.
Had passed an order on 9/4/2025.
Sorry, Your Ladyship.
No, not 9/4. Before that is the order. Had passed a detailed order on 21/3/2025, and the learned and the learned judge has discussed elaborately and considered the submissions and the law. And directed the mother to bring the daughter to the court premises on 7/4/2025 and keep the child present before the registrar judicial at 11 a.m. Whereby then on 8/4/2025, no, where is that with regard to the changing of the custody? Where is it? In the
That, Your Ladyship, is 21-3, at the bottom of 21-3.
21/3. 3. That I'm not able to find. That's what I'm searching for.
The last paragraph, I'll just tell Your Ladyship, I think it's paragraph 35.
The 21/3 order.
In 21-3 order, Your Ladyship, the paragraph at page 26, last, and
The respondent is directed to bring the child.
yes, and then at page 11 and 12.
11 and 12.
Yes.
Considering the fact that the child is engaged about 10 years and studying in class 5, it would be important to the child to grow up with love and affection, and also both maternal and paternal grandparents for proper physical, mental, and also emotional development. And also the fact that minor child has not expressed any aversion against the father or grandparents. the court had granted 50% of the summer vacation starting from 6/4/2025 to 2/5/2025. Where the place where the minor child grew up from the year 2014 and spent quality, loving and affectionate time with the grandparents till 2021, and accordingly directed the mother to present the girl before the registrar judicial on 7/4/2025 at 11 a.m. The said order was not complied with by the mother, and she has not kept the minor child before the registrar judicial on 7/4/2025. When the matter came up before the court, the counsel appearing for the mother submitted that he has no any information with regard to the whereabouts of the mother as well as the child, and he is unable to contact the respondent mother. Then the court has passed an order on 8/4/2025 directing the mother to keep the child present on 9/4/2025 at 2:30 p.m., failing which precipitate and coercive action would be taken, including issuance of bailable and non-bailable warrants against the mother for flagrant disobedience of the orders of the court, and directed the matter to be listed on 9/4/2025. On 9/4/2025, again, the learned senior counsel and the counsel on record for the respondent, they said that they are not aware of the whereabouts of the mother. Then the court has directed the Commissioner of Police to furnish a report with regard to the correct whereabouts of the mother and the minor child to the registry. And if they are available within the jurisdiction of the court, they are restrained from leaving the jurisdiction. Then on 16/4/2025, it is brought to the notice of the court that the mother had approached the Honorable Apex Court, and the Honorable Apex Court had modified the order passed by the court dated, what is that, 21/3. 21/3. Then the court has passed an order to comply with the orders of the Honorable Apex Court. Then the matter came up before this court on 21/4/2025. Then, in the line of the orders passed by the Honorable Apex Court, this court has passed the following order: extract the only operative portion of the order, and directed the mother to present the girl, to hand over the girl on 22/4/2025. Then on 24/4/2025, another order is passed by this court. It is submitted that by the counsel appearing for the respondent that on one day, on 22nd, after spending the whole day in the registrar's office, the girl was not feeling well and she was taken to the hospital. She was completely stressed, and the doctors also advised that she requires the counseling. And it is also submitted that the girl is reluctant to meet the father and the grandparents. All the parties shall go for the counseling, and the girl shall be convinced to talk to the father. And at that time, the court has also perused a report placed by the registrar, and also observed that it's a clear case of parental alienation and complete tutoring by the custodial parent. As per the report of the Registrar Judicial, the girl has stated that the girl has shown hatred and the kind of aggression and is very much evident from the report of the registrar, wherein she stated that she is not an object and she will not meet the father. This court also observed that the way the mother is tutoring the daughter and bringing up the daughter is definitely not in the interest of the minor. And court also observed that daughter requires the love and affection of both the parents, and mother has no right to deprive the daughter of her happy childhood. Then this court has passed an order that as per the arrangement, the visitation shall go on as per the order dated 21/3/2025. On 26/4/2025 by 11 o'clock, the mother shall bring the daughter to the Registrar Judicial and the father can take the child, and during the stay with him, the father shall take the girl for counseling on every day at Gurgaon. If the mother wants to be part of the counseling session at Gurgaon, she is at liberty to participate in those sessions. Then on 26/4/2025, when the matter is listed before the court, it is brought to the notice of the court that it is stated that they filed a prescription of Kaveri Hospital, wherein it is stated that the girl has disturbed sleep, anger outbursts, irritability, low mood, loss of pleasure and interest. It is stated that the child is undergoing all these symptoms because of the court hearing and the fear of being taken away from the mother, and the doctor has advised the girl to take the tablets. And they also stated that the child has to be accompanied by the primary caregiver in hearings, public member of the Child Welfare Committee, and further advised to avoid all triggering situations and to ensure cooperation with the mother. This court has observed that on 24/4/2025, when the mother came to the court, there are no complaints with regard to the health condition of the child. And it is only stated that the girl is reluctant to go to the father. And the court also observes that there is an intention on the part of the mother not to give the custody to the father and to get away from the successive orders passed by different courts. And the mother at every stage is showing reluctance to obey the orders of the court. And the adamant attitude of the mother is reflected in the girl. Then the court has passed an order that the child protection, then the court has passed the following order: extract this operative portion of this order. Then on 29/4/2025, when it is brought to the notice of the court that it is stated that the mother has left to Delhi. According to the counsel, he had informed to the mother at the late night on 26/4/2025. And even on 28/4/2025, when the matter came up, he has not chosen to bring to the notice of the court that she left to Delhi. The court has observed that at every step, mother is trying to overreach the orders of the court and showing scant respect to the orders of the court. And also, if the orders passed by the court remain to be the paper orders, then the common man will lose hope in the system. And it's a duty of the court to see that the order of the court is implemented in its true spirit. And accordingly, bailable warrants were issued against the mother and directed the matter to be listed. Bailable warrants were issued, and the Commissioner of Police, Bangalore, the Commissioner of Bangalore was directed to ensure that the mother and the daughter were produced before this court on 2/5/2025 by 10:30 p.m. On 2/5/2025, it is stated that the officers are present before the court. On 2/5/2025, that according to the police, she is within the vicinity of the Honorable Supreme Court. And the team of officers are there, and they will be executing the orders of the court. And this court has reiterated the earlier order passed by the court. The Honorable Apex Court had, as far as the application that's filed for the review by the mother is dismissed, and with regard to the bailable warrants or the warrants are concerned, as it is submitted by the mother that she will appear, court is directed not to execute the same. Then, as per the order passed by the court on 8/5/2025, the child evaluation is done by the NIMHANS. And the order dated 8/5/2025 reveals that the report is placed before the court as per the order dated 2/5/2025, and it is put up before the court and are directed to put up the same on 13/5/2025. On 15/5/2025, a coordinate bench of this court has passed an order wherein this order portion next time. Today, now the report is placed before the court. Where is that report? As per the report, completely, the report reads thus, completely extracted.
The report dated 22/5.
Dated 22/5/2025. In the light of the said report, it is stated that the proposed inpatient admission is for the purpose of diagnostic clarification and clinical management. And the objective is to offer neutral evidence-based input in full compliance with the court's directive. And the recommendation is made solely in the interest of safeguarding the child's long-term psychological well-being and best interest. This report is placed before the court by the Associate Professor, Department of Child and Adolescent Psychiatry, and the Assistant Professor, Department of Clinical Psychiatry, and also this court has permitted both the mother, both the counsel appearing for the mother as well as the father to go through the report when the matter came up, due the date yesterday. So and so. Today when the matter came up, then counsel appearing for the mother submits that he has gone through the report and also the other record, medical record. According to him, as per his submission, the girl has no mental illness When the girl has no mental illness, question of admitting her in the hospital will not arise. Further, when he has given a report, it should have been supported by some medical record or observations. And according to the council, the report that is submitted by the NIMHANS is without any basis, and unless and until there is a basis for such a report, that cannot be considered. The main thrust of the argument of the council for the mother is that when there is no illness, the admission is not required. And when the court poses a question, then what mother will do in these circumstances, the council will ask a question to the court what the mother should do. And you would submit that mother is doing everything, and she cannot, and nothing more is expected from her. If the girl is reluctant, and slowly they should both of them have to attend the sessions, and then should make the girl meet the father, and the treatment as suggested or the report, according to him, the word treatment shall also not be used, and as suggested, the report as placed by the NIMHANS has no, it is legally not a valid one, and he relies on the medico-legal ethics guidelines, and in that A deals with responsibilities to the evaluee, and B deals with responsibilities to society and the court. In that, he relies on point number 39 and 40, which reads thus: extract these two. Basing on this, that this opinion of the doctors of the NIMHANS is without any basis, and it cannot be implemented. Land counsel appearing for the petitioner father submits that when a report is called from the NIMHANS, which is a prestigious institution in the entire country, and they have given a report, whether that report, what is the sanctity, or medically what is it can be, it is correct or not, neither the councils nor the court has the expertise to decide it. In his submissions, he has stated that if this kind of admission is passed by the court, it would become a norm, and in all the cases, it would be in every case, wherever the child is reluctant to meet the father, the admission would be necessary. Continue his submission. With regard to the submission that it cannot be a norm, then counsel appearing for the father submits that this is not a normal case, and any order, the orders are passed by the court basing on the facts and circumstances of the case. The said submission, the cannot be considered, and this case cannot be equated with any other custody case or in any other custody matter. It is submitted that unless and until a complete evaluation of the child is done, it would be very difficult. It is, the father will not be able to meet the child, because whenever an order is passed by the court, the mother will come up saying that the father is not interested, child is not interested to meet the father. Why the child is not interested to meet the father? It requires a psychological analysis, and that analysis can be done by the NIMHANS, and it would it would put an end to all this the issues that are being to all the issues, and it would be in the interest of the child. Next paragraph. Having heard the counsels on either side, peruse the material on record. With the earlier, this court had seen in a few cases where both the mother and father are at loggerheads, and the custodial parent was trying to influence the child, and the influence is such that in a normal way, even if the interaction by the court or a simple counseling was not of any help, and when a report was called earlier from the NIMHANS in other case, then they said that the inpatient it has to be evaluated by admitting them in the hospital. Then the court had asked the registry and spoke to and connect to the director NIMHANS, and had an interaction and had a detailed discussion with him with regard to this. And particularly, the court has asked the director NIMHANS, a child of this age, where in the hospital there are patients of severe mental illness, why they should be admitted, and why not the therapy, the counseling sessions cannot be taken up to understand the problem of the child and the parents. It was stated by the director NIMHANS that with all their experience, where the parents who are having these kind of disputes, and when the child is with the custodial with the custodial parent, they are completely influenced by them, and they will, in spite of their best efforts, they would not be able to understand and evaluate what is the mental state of the child. In those cases, only through the admission and with their constant care and supervision, they will be able to evaluate the psychological and the state of mind of the child. When the court asked about the facilities at NIMHANS, it is stated that they have a completely different child ward where they're completely kept away from the mentally ill patients, and as if like they'll have the normal sessions like how it happens in the school and what they generally do, the day-to-day activities, and accordingly they'll be able to come to a understanding and able to give a report to the court. The objections that are raised by the learned counsel for the petitioner, learned counsel appearing for the respondent mother, this court is not able to appreciate any of those submissions, particularly with regard to the submission that the girl is all right, and unless and until she has mental illness, she cannot be admitted in the hospital. Neither the court not the council, has any expertise to say that. We have sought for a report from the Nisman, which is considered to be a prestigious the hospital in the country, who are very good at dealing with these kind of things. For asking a particular child to be admitted in the hospital, neither the council is submitting nor this court able to see that there are any vested reasons for the doctors to tell that, to advise that the child has to be admitted in the hospital. In the preceding paragraphs and in the earlier orders, this court has observed that a girl of 10 years is able to say that she is not an object and nobody has a right to deal with her, to decide her life, including the courts and the judges. And she will do what she wants to do. Generally, it is not expected from a 10-year girl to speak in that fashion unless and until there is a constant tutoring from the mother. The whole endeavor of the court in hearing this case so many times and passing several orders by this court, by the Honorable Apex Court, is the interest of the child and interest and welfare of the child. The mother's interest, and according to her, the welfare of the child is that the treatment, the code, everything should go as per her own intention or as per her own whims and fancies. In the preceding paragraphs, this court has discussed the manner in which the mother is fighting tooth and nail, and conveniently, and how the mother is disobeying the orders of the court. Orders of the court shows that her only intention appears to be that the girl shall not meet the father. And for that, she is going to any extent. This court exercising the parents' patria jurisdiction cannot let the mother deal with the girl's life in such a manner, which will have a long-lasting consequences on her life. When, as it is informed to the court by the director Nimhans, and in the other case, where this case is a fit case, where the doctors needs to evaluate the psychology or the other psychotic aspects with regard to the child who is showing that kind of reluctance, aggression towards the father and the grandparents. As per the evaluation made by them with the child has not informed to the doctors about any kind of violence or any kind of overacts from the father. And even as per the report, the mother has stated things which were not at all the concerns by the daughter. Hence, this court is of the view that as per the report placed by the Nimhans, she has to be evaluated. Accordingly, this court is passing the following order.
Evaluated as an inpatient.
Have evaluated as per the report.
As per the
As per the report. No, before that, evaluated as per the report. if this evaluation is not done and on a, as an outpatient, being in the custody of the mother and with the constant tutoring from her, it is very difficult for the doctors to evaluate the child, and it cannot go anywhere. And again, the parties will be going around the courts without there being a positive material evidence before the court. Hence, in that view of the matter, the court is passing the following order.
Leadership, at the bottom of page of order dated 2/5, the court has directed the district child protection officer.
That's what that order
very
only I'm looking at. The Department of Child and Adolescent Psychiatry, NIMHANS. No, it's not that. Where is that order?
2/5, Your Leadership. 2/5, 2nd of May.
Yes. The District Child Protection Officer, Kamanekal Taluk, Bangalore, Rural, Ms. Asha Kumari, is directed to take the child's father Sahai on today is 5th.
Saturday maybe.
On 7th. On 7/6/2025.
Requesting that sufficient time is given so that they can challenge the. Requesting that sufficient time is given so that they can challenge the song.
On 9th.
There is hardly next working day, and this is the only working day I have. Requesting that at least 3-4 days, up to 15th time maybe.
On 12th, we'll say.
12th.
On 12th. Anekal is directed to take the child Sada Sahai on 15/6/2025 at 11:30 a.m. along with the mother, deciding at entire thing you with all the details you to the NIMHANS, and as per the report dated so and so 22/5/2025, they shall as an inpatient as per the report dated 22/5/2025, the evaluation shall be done and the report shall be placed. How many days they said as an inpatient?
4 to 6 days.
Once the evaluation is done, as per the report shall be placed before this court. Next one. The hospital, the NIMHANS shall take, the director NIMHANS is directed to take all the steps and to see that an environment, the girl shall be kept in an environment where she is away from the mentally ill patients, and shall see to that she is comfortable all to.
I have a request, Malad. So far as the order that is passed at this moment, I see that there is a reference of a previous case wherein something of similar nature had taken place, and it was stated that on factual grounds it is more or less a match. But if the details of that case could be provided in any case, because it seems without a reference again, it would be very difficult.
That's not required for you.
Much obliged.
I'm obliged.
Yes.
Cell number 29.
I'm appearing for the petitioner father.
10 Michael Perez.
My lord, in this matter, this is arising out of a JNWC petition before the Honorable Family Court.
What is this order dated 2/8/20?
Oh. My lord, the order is, I had filed IA1 during the petition filing.
Let's see that order dated 2/8/24.
To stay the entire proceedings. However, when the order was uploaded,
yes.
Oh, my lord, when the order was uploaded, by oversight, the order has been passed. There's no representation on behalf of the respondent. Considering the same, there shall be stay of all further proceedings in IA number 6 in GNWC 169 of 2020. Now, I am for the father. I had obtained part visitation rights before the Honorable Family Court. I had come before this Honorable Court for enhancement of my visitation rights. In my IA 1 of 2024, I had asked for stay of the entire proceedings.
No, who was the counsel then?
I was the counsel, my lord, for the petitioner. I had asked for stay of the entire proceedings. However, the order uploaded is for staying.
No, but I will not grant the entire stay in any of the matters.
Oh, I do not want stay. I do not want stay. Unfortunately, my visitation right has been stayed. That is why I've asked to recall that order.
But you're not there when the order is passed.
On 2/8, my lord. 2/8.
That's what I'm saying. On 2/8 you were there.
I was there. I'm the petitioner, my lord.
That's what I'm saying. You were there. The court is passing the order. That time you should tell the court.
My lord, I think while uploading the order, while hearing.
Not uploading. What is dictated in the order, the same will be. In my court, the stenographers will not add anything. So when you're hearing it, maybe it's oversight by the court. We should have avoided this.
Yes.
Because it's dictated in the open court.
Yes, my lord. At that
You
time,
should have understood that.
At the time, what I heard was that the entire proceedings were stayed.
I never say that. Entire proceedings, I never say. I always say whenever there is an stay, it's on IA. There shall be stay of all further proceeding. Question to the IA would be the order.
Because the difficulty will be I cannot meet my child in view of this order.
Yes.
So
you have on 2/8/2024 an order. The petition father is before this court, questioning the quantum of visitation that is granted, and in this court. Then why did you ask for stay of the proceedings in GNWC?
For the entire proceeding, Manu, because what has happened is she has.
You are the one who filed the GNWC.
No, I did not file. My wife has filed. Even though she had the child in Bangalore, I am residing in Gujarat.
What did you write? Questioning the quantum of the visitation that is granted, and in the operative portion of the order, considering the fact that the respondent is not present, the court granted stay of all further proceeding in I number 6. It is submitted that by staying the proceedings in IA and the order dated 10/11/2023, the petitioner is not able to exercise the visitation. Considering the same, the order is then what is to be done now?
I may be dismissed as not press. I number 1.
Considering the same, and he submitted that he sought for the stay of the all proceedings in the GNWC itself. This court is not inclined to stay all further proceedings in the GNWC. In that view of the matter, what is this IA?
IA 1 was for stay, my lord.
IA number
1 of 2024.
IA number 1 is of 2024 is dismissed as not pressed. Yeah. Next.
Lord, may be taken up next week for hearing, my lord.
This is next week. Yes. 30.
Anjana Church. For petitioner, Geeta.
Your Ladyship,
yes.
We had filed this WP asking for a transfer of the germane case in GNWC 141 from 3rd additional to any other court because our allegation is the respondent is browbeating the judge. Subsequently, the transfer has taken place, which means the judges have been transferred. It renders our prayer infructuous because that particular judge is no longer on the list to deal with this matter. In fact, this matter has gone up to registrar vigilance on the complaint of the other side, and we are now withdrawing it because we don't need to press this.
Very strong objections this submission. The respected learned judge of family court has been transferred to now. As in the regular transfers?
Yes.
Who has given the complaint against the officer?
The mother.
No. Again, wrong submission. Does he have his document for that?
Yes, we have applied under RTA. We have applied.
No, if she has given the complaint, why should you file this petition before this?
That is because, first, the judge was actually giving orders in accordance with law. After this incident happened, in fact, they are very serious allegations. Then, your Ladyship will be pleased to see and surprised that there is a record over here as to how The alimony has been discussed and has entered. Because here, this case.
The registrar judicial, please wait,
Yes,
the registrar
yes.
judicial is direct to place before this court.
And even the
Whether any complaint is received
registrar vigilance
against
also.
you will take from the vigilance.
Please, yeah, you will get it.
Any complaint is made against
Deciding officer.
who was the judge then?
Third additional
What's the
principal
name?
family court.
Prabhavati V. Hireman.
No, ma'am. Srimati Sharada.
What is her name?
Sharada. Srimati Sharada.
What is, no initial?
I do not know the initials, ma'am.
Sharada, Srimati Sharada, who was the then judge of the
Third additional principal family.
Third additional principal family court. This is matter on Monday.
Public.
This particular, I don't know which they will be, but yes, there was one communication which was.
No, the cat is out now.
May I see the registrar judicial clerk that 2 divorces have been filed. One divorce was filed by the mother in the West Bengal court.
We will see.
That is not the contention which there is.
Let it come. No, you were saying that nothing of that.
Correct.
But still it's
Highly obliged.
Monday.
Cell number 31.
May I request, the trial court matter is also on Monday, so if you could shift it.
Tuesday.
Tuesday. Highly obliged.
31.
Cell number 31. Rajeshwar PN.
Waiting for the petitioner, my lord. Kindly have it next week, my lord.
What is this? Vacating the interim order. When is the order granted? Let's see.
My lord, the order was granted on 1/2/25, my lord. Senior's relative, close relative has passed away, my lord. We are complying with the orders passed.
Complying?
We are complying, my lord.
Vacate stay petition is filed and there is no representation on behalf of the respondent. Then comes to the petition submits that they comply with the order passed by this court.
Interim order may be
Interim
extended.
order earlier and request for time that the council is not feeling well. This is matter after 3 weeks. Interim order earlier granted is extended till then. Yes, next.
Cell number 32.
I appear for the petitioner in this matter, my lord.
Yes.
My lord, the petitioner, the respondent is the adopted daughter of the petitioner, my lord, and she filed a petition under
One
section
minute.
1.
Okay, what is it?
My lord, I'm a proxy for this, my lord. The advocate on record is following this. My lord, I request a week's time to have it for hearing, my lord.
Yes. The request is this matter after 2 weeks.
Obliged, ma'am.
Respondent. Yes, next.
17.6. Cell number 33. Yamma Nagabhushan.
Seek for a two weeks adjournment, my lordship. After 2 weeks adjournment.
Yes, the request 2 weeks. Next 34.
Cell number 34.
Interim order may be granted.
Interim order earlier granted is extended till then. No representation on behalf of the respondent. Yes, 34.
34.
No representation for dismissal tomorrow.
Cell number 35.
Counsel for the
Usha
petitioner
Reddy.
lordship. Counsel for petitioner lordship. We have filed this petition seeking direction for expeditious disposal of the matrimonial case, which is pending since 2020 before third additional FC. 2020.
Which court?
Third additional FC. Family court.
Bangalore.
Yes, yes, your lordship.
No. Third additional?
Family court, principal family court, Bangalore.
Just find out. This third additional principal court, family court, Bangalore, which is the oldest case, and ask for the pendency of the cases.
Your lordship, if I may submit. Just for filing their objections, they took 1.5 year time, your lordship.
That's what we'll find out. We'll find out and list this matter on Monday. Get the statistics.
Cell number 36.
Much obliged.
36.
For representation for dismissal tomorrow.
Cell number 37.
I am for the petitioner in this matter. My lord, petitioner has questioned the interim order of maintenance passed by the family court Chikbalapur.
Petitioner is a husband.
Petitioner is a husband.
How much is granted?
6,000 is granted, my lord.
What
My lord,
is-
the
what is-
respondent is having the sufficient income, my lord. She also,
Your income.
sorry, my lord.
What is your income?
My lord, as per my lord, I am taking the 30,000 rupees compensation, my lord. That is not an income, my lord.
What compensation?
But my lord, I am trainee, my lord.
I am,
What is the compensation what is that compensation you are getting?
my lord, 30,000 rupees taken. My lord, the respondent is.
What is that? What do you mean by compensation?
Compensation, my lord, I am joined the new company, my lord. They are giving the compensation of rupees 30,000, my lord, for the particular concept, my lord, for the particular project, my lord. After finishing the project, my lord, they may left the.
No, why it will be called a compensation that I'm
But
not
my
able to
lord,
understand.
as per the statement made by the petitioner, my lord, I am saying that, my lord. But he is taking the compensation, my lord.
So whatever it is, when you work,
He is
you
getting
pay,
the 30,000, my lord. But my lord, she
salary
having the 50 lakh rupees FD, my lord.
in her name.
In her name.
Was it placed before the court?
My lord, I have produced the, my lord, I am stated in page number 12,
page number before
but
the
one
trial
FD
court.
is produced before the trial court, my lord.
Let's see what is the observation of the court on that.
But the court has observed, my lord, she getting the 45,000 rupees rent income, my lord, but not stated about the FD, my lord.
What about
Please
your
take-
income? What is the observation of the court?
Please, my lord. But with respect to, my lord, respondent income, my lord.
We'll see. What about your income? What about her income? What is the discussion by the court?
My lord, page number 24, my lord.
24.
Page number 24, my lord.
Come to the reasons. From the reasoning part, we will see.
That's
that
correct.
is
Reasoning part, my lord, only my income is stated, my lord, but her income is not stated.
65,000
But
per
I have
month.
stated.
It is the contention of the respondent that the first petition is having land per month. Respondent states that you have executed a release deed when on 6/12.
Please, my lord. But my lord, is he having the FT of rupees 50 lakh rupees, my lord? My lord, this is the interim maintenance, my lord. Without going the document, my lord.
At least where is your contention that she is having the
My lord, kindly see, my lord, my statement of objection. Sir.
page number?
Page number 55, my lord. Starting from 54 bottom, my lord, it is submitted the petition number 1 having the agricultural properties in survey number 1/6.
You're reading where?
Please,
You're reading where?
my lord, page number 54 bottom, my lord. Para number 22. It is submitted the petition number 1 having the agricultural properties in survey number 1/6 measuring 13 and half guntas. Survey number 9 measuring 38 acre guntas. Out of 1/3 share of her, the properties are valuable properties and she is earning more income in the rents and agricultural properties. The petition of one earning.
And what are the material before the court to substantiate this?
My lord, we have produced the RTC before the family court, my lord.
That is agriculture land. What about this 45,000?
45,000 also, my lord. She is getting the rent, my lord. The property is also stands in her name, my lord.
How the court will know that she is getting 45,000 unless and until a document is placed?
But my lord, that is the residential house, my lord. She let out the residential.
That's not the way. Without evidence, why will the court consider all this?
My
all
lord,
the oral
my lord,
submissions?
I have produced the FT, my lord.
6,000, which is a very meager amount.
My lord,
unless and until
my
there is evidence
submission,
on
my
record.
lord, she is capable to lead her
We
life.
will see, we'll
But
see
my lord,
once she
with
comes.
respect to child, my lord, I am ready to pay 3,000 rupees, my lord. My humble submission, my
Do
lord,
you
I am
think
ready to
that,
pay.
do you think that with 3,000 the child can live?
Please, my lord.
No. Notice to the respondent.
My lord, my submission, my lord, he is the recently job holder, my lord. He is not.
Even if
he
you
also having the
even
rented.
according to you, you are getting 30,000, court said 6,000. It is not a
My lord,
problem. And think that you are giving 6,000 to the child.
but during pendency of this,
Yes.
During
no.
pendency of the case, my
Notice
lord,
to
I
the
am ready to pay
respondents.
3,000 rupees to the
Petition is
judge.
permitted to take out no hand summons on the counsel appearing with the respondent and file a memo to that effect. Once a memo is filed, list the matter. Next.
Cell number, for admission matter, cell number 38. Santosh.
Yesterday also there was no representation. Let's give the. Yes.
Petitioner, who is the husband in the trial court, my lord, and the respondent wife, she has filed a maintenance petition.
How much is granted?
She sought for 20,000, my lord,
Hmm.
and the
Court has
family court granted 4,000, my lord.
You can't pay 4,000 also.
My lord, that is the issue is that, my lord, there are no issues out of the wedlock of the petitioner and the respondent, my lord. There is no dispute that the petitioner earlier, who is a wife, she has filed an earlier petition, that is criminal miss in the year 2015, and that was also withdrawn. That is also not in dispute, my lord. And further, she has also filed a divorce petition against the husband. That was also withdrawn, my lord. So that is also, it is not in dispute, my lord. That MC 125 of 14, that was in the trial court is marked as Exhibit P5, my lord. That document may kindly be seen for a moment.
Please tell the court.
Please, my lord.
Let us take into consideration and let us accept that she has filed the criminal miscellaneous, withdrawn. She filed MC, withdrawn. Now she filed something else now.
Please.
But will it disentitle her from filing this application?
No, my lord. The thing is, my lord, she has unequivocally admitted that she is running a orphan home, my lord, and also getting a grant from that also she has admitted, my lord.
So for running a orphan home, if she is taking a grant, will it give her the money to live?
No, my lord. For a moment, my lord, I will enlighten this court regarding one document. After filing this petition, I have filed one document with memo, my lord. For a moment, that document may kindly be seen, my lord. Earlier, she filed that petition for interim maintenance before the family court. So family court rejected that claiming of the maintenance was rejected, my lord, interim maintenance. I may be permitted to read that portion.
No, we'll see the reasoning in this case.
Please, my
How the court is wrong.
My lord, kindly consider the para number 11, my lord.
Yes, please read.
Para 11, page 11 of the
We'll read from para 9 itself,
Please,
so that it will be clear. Yes.
The petitioner has filed this petition under section 125 of CRPC against the respondent seeking maintenance of rupees 20,000 per month by contending that respondent has subjected her to harassment, caused cruelty and neglected to maintain her without providing basic necessities, etc. In spite of several advice and panchayat also, the respondent did not stop his behavior and not stopped giving harassment to the petitioner. The respondent has no avocation and source of income for her livelihood, but it is wrongly typed as respondent. My lord, the petitioner has no avocation and source of income for her livelihood, and he has not made any arrangement for her maintenance. Even though the respondent is having sufficient source of income by owning immovable properties and agricultural lands, failed to maintain the petitioner. The respondent is capable to pay maintenance to her. Per contra, the respondent, though he has admitted the marriage, but denied the allegation of harassment and neglecting the petitioner. The petitioner is having sufficient income to maintain herself. The petitioner has filed this petition to harass the respondent. The petitioner had filed similar maintenance petition and withdrew the said case. In support of the case, petitioner herself is examined as PWN, who in her affidavit evidence has reiterated the petition averments. The petitioner has produced photo at Exhibit P1, certified copy of the order sheet of criminal miss 315 of 2015 as per Exhibit P2. Certified copy of the petition and objection statement of criminal miss 315 of 2015 as per Exhibit P3 and P4. Certified copy of order sheet, certified copy of the petition, certified copy of the objection statement of MC number 125 of 2014 as per Exhibit P5 to P8. Certified copy of the marriage invitation card as per Exhibit P9. Certified copy of the photo as per Exhibit P10 and certified copy of the affidavit as per Exhibit P11 and B register extract as per Exhibit P12. In this case, there is no dispute regarding the relationship of the petitioner with the respondent. Petitioner earlier against the respondent. Hence, from these documents, the marriage of the petitioner with the respondent and petitioner earlier filing of the case against the respondent is proved. Next important, during the course of cross-examination, PWN has admitted the opening and
When your
established.
respondent is not there,
Please, ma'am.
I am not inclined to allow this petition. Will
Please,
adjourn.
ma'am, it records may be called for my meantime because
Admit.
under the interim order
Call
may
for the
kindly
record.
extend.
Huh?
Interim order
Yes.
may kindly be extended.
Admit, call for the TCR. No representation for the respondents. Post after, after 2 months. Interim order granted is extended. Next.
Please.
Yes. Next.
Cell number 39. Kalpana PB.
For the petitioner husband, my lord. My lord, the wife.
This amount granted.
Wife had filed a DV petition under Domestic Violence Act as well as in this act.
In that, how much is granted?
In that 15,000.
In this?
In this, it is 6,000.
6,000. Altogether 21,000. What is your income?
My lord, I work as a BSNL employee and my income as on that date was 31,000 gross.
30?
31,000. Then later, yeah.
So on what grounds you are before the court?
My lord, already I have paid, up to now, my lord, I have paid 19,40,000, my lord, towards the maintenance. From 2015, she had instituted a case in.
What was the interim order by this court?
There is no interim order.
And
This is a main, my lord, main order, my lord. This is a main order.
Oh, no. In the main order, in this, any
Yes,
interim order is granted. That's what I'm saying.
In this case, my lord, interim order, I don't have an interim order. Interim order is not being
And you are
granted
paying.
by this court, my lord.
And you're
This-
paying.
Yes, my lord.
So you have no difficulty to pay.
No, I am paying 15,000 under DV Act, my lord. In this case, whatever that has been awarded, I have not paid so far. I have challenged this on the basis that.
So there is no stay, but you're also not paid.
I have not paid, but they have filed.
Please come to the order.
My lord, in this case, I just wanted to, page number 57, my lord, order portion. Wife is entitled monthly maintenance of 4,000 and 2 children, my lord, 2 and 3 together are entitled for 6,000. So altogether 10,000 has been granted, my lord. So I am paying 15,000 under the DV Act and here I have to pay 10,000.
Just now you said 6,000 to the wife.
No, 6,000 for the children.
And
4,000 for the wife. So altogether 10,000.
It comes to 25,000.
Yes, my lord. So I'm just seeking.
Your income that time was 31,000.
Yeah, now it is 40. I'll just. Now my gross income is. Take home is 57, my lord. My income is 57,166.
Then what is
as
the
on
difficult-
21?
What is the difficulty now?
My lord, the first aspect is I'm already paying 15,000 per month.
But still, there are
I
two
say-
children. No, family consists of 4.
Yes, my lord.
3, 1. And one person, even if you pay this 25,000, still you are left with 30,000.
My lord,
And
I
is it
have
your
to-
case that the mother is gainfully employed?
The petitioner number 1 is gainfully employed, my lord. I have also produced a document, series of documents. She has filed assets and liabilities. She has not disclosed anything about her income, wherein I have filed a petition for perjury because she has not disclosed
According
her
to you,
income.
what is the document filed by you to show that?
My lord, I have produced a document pertaining to the income tax, TDS, and also EPF, and also the bank statement. Whereas on
As per
confrontation,
that, no, I'm not asking.
yes, my
what
lord,
is that?
as per that, she draws around 24,000 per month. I have produced the TDS
Was
from
it
the
not considered
department.
by the court in this?
That has not been considered, my lord. The court has not considered that. In fact, my lord,
There is no reference to that. The exhibits are not discussed.
the exhibits, the court mentions that I have produced the exhibits.
Where do you
But
get
it
that?
doesn't say anything.
Where do you find that?
Yes, my
Exhibit number?
My lord, the exhibit is from 37 onwards.
Attested copy of documents produced by respondent before the Commissioner of Income Tax Department pertaining to the.
My lord, page number 48, paragraph number 43.
48,
my lord. Paragraph number 43. The respondent, may I read, my lord? Subsequently, the respondent has brought on record Exhibit R37, which is an attested copy of the document produced by him before the Commissioner of Income Tax Department pertaining to the petitioner number 1, copies of IT returns, form number 26 AS, TDS for the period from 11 to 12 to 22 to 23, being employee of Hinduja Global Solutions. No tax was deducted from 2021. It means the petitioner number 1 was working and getting salary. In spite of this, Exhibit P8 is a document produced by Sybil Consumer CIR pertaining to petitioner number 1 in connection with her transactions. Exhibit 39 is information given by EPF, organization dated 3/12/2021, to show that petitioner 1 had 2 EPF accounts. One was settled and the other was transferred on 14/9/21, and another one was settled on 22/1/2016. Exhibit R40 is another document in connection.
Then we do one thing, whatever the amount that is granted to the wife, we'll say that she is not entitled, but for the children?
My lord, I'm already.
What your children require?
Yes, my lord. My lord,
15,
what?
15 and 6, 21.
It comes to 21, my lord.
And as far as the wife is concerned, whatever that is granted to her, we'll
My
set
lord,
aside that.
this 15, whatever I am paying for the children as well as to the wife. So that is under question, my lord, before the district court. The matter is, the orders are yet to be pronounced on that order, my lord, DV Act order. So excluding the wife, even then I'm paying that amount to the children, my lord. And in fact, my lord, I buy the jewelry for the children. I have also produced those documents. And I send grocery items.
Coming up before the district court.
Yes, my lord, it's still pending.
When is it coming? You said it's coming up.
Yes, my lord, it is posted for orders on 17/6.
This is matter on 23rd, 23/6.
Yes. Number 40. Muhammad Tahir.
My lord, I'm sorry, my lord, I didn't. Is it urgent?
23/6.
20.
After that case.
Yes. In fact, my lord, I have filed a restitution for conjugal rights, which is pending before Tirupati, court at Tirupati. And in that also the order is pending on 17/6.
17/6. That's why I posted it to 23rd, 26th. Yes.
23/6. Serial number 40, Muhammad Tahir.
Husband got a modification of the order, Lordship. The wife has filed maintenance for the wife, for herself and daughter. The court has granted 8,000 to the daughter, Lordship. Subsequently, husband has appeared before this honorable court. He filed a petition. He has modified to 5,000 rupees. Neither he supplied a copy to us. Even that 5,000 also is not paying. And we are before this honorable court.
For the petitioner in RPFC 196 of 2024 is present. No representation for the petitioner in RPFC 289 of 2023. List RPFC 289 of 2023 for disposal. Along with this on.
Even we attempted to deliver a copy, to serve our copy. He also refused to take our copy.
Let it come. If it's not there, his petition will discuss.
Yeah.
Wednesday.
Yes. Serial number 41, Kiran Kumar. Serial number 41, Kiran Kumar. 7th.
I am for the petitioner. I seek
Petition
time.
not well.
Petitioner is not well.
It's submitted
Kiran
and then
Kumar.
counts to the petition.
Granted and petitioner in order, asking the petitioner to pay 10,000 per month and to deposit all the arrears at the rate of.
That's not done till now.
Then it will be vacated. It is a condition.
A week's time, my lord, because the council is not well. A week's time.
2 weeks. Let somebody represent with regard to the complaints of the order. We cannot, we'll have it on Tuesday.
Tuesdays.
Tuesday. So we are not granting anything. We'll have it on Tuesday. It is submitted, but the counsel for the petition is unwell. List this matter on Tuesday.
Cell number 42. Lakshmikant M. Duge.
For respondent, my lords.
No representation for the petitioner. Counsel for the respondent is present. This is matter after 4 weeks. Yes, next.
Cell number 43.
Sir, I appear on behalf of the petitioner, my lord. The delay, my lord.
IA number 1 of 24 is filed to condone the delay of 267 days in filing the petition for the reasons stated. Delay is condoned.
And the
Call for the records. Next.
Cell number 44. Lalit Jain.
Husband's petition.
Why? At the request of. Serve him the copy.
Let's, it was sent through email. I will send it again.
Then counsel the respondent seeks time and counsel the petitioner shall serve the copy of the petition on the counsel for the respondent. This is matter after 2 weeks.
Cell number 45. 45. Hiramat Praveen Kumar Appaya.
So far notice is not ordered to the respondent.
My lord, only order was the earlier order was that call for trial court's record.
No notice.
No notice was. There are.
Admit notice. I think it's not. It doesn't reflect notice to the respondents. Next 46. Post after service of notice.
Cell number 46.
The petitioner is a working husband. His husband. His salary, monthly salary is 16,875.
We'll see once after the notice is served. Yes. 46.
46. Latif B. Soya Kerala.
Appearing for petitioner, my lord. Like submitted a memo along with the acknowledgement, my lord.
You wanted to verify whether the amounts are paid or not.
Yes, my lord.
May is only the one. Yes. Does this matter? After 4 weeks. Interim order earlier granted is extended till then. This 47.
47.
I appear for the petitioner in this matter, my lord.
Yes.
This is the husband's petition against the order of the family court, my lord, awarding maintenance to the wife and children. Both the wife and children are staying in the house, my lord. They are sharing the same residential premises. She had filed a petition for restitution of conjugal rights and she is joined, but she is staying separately. And he is providing for all, providing for the children's education as well as their.
No, what is the amount that is granted?
25,000 for the wife and 12,500 each for the minor 2 children. You know, now he is in a precarious condition that he has lost his job, my lord. He was on notice period when I filed the petition. And he is from 18 March, he has no
So
job.
it is how much altogether it is?
50,000 per month.
50,000. What was the income?
At that time, my lord, he was earning about 1.5 lakh rupees.
1,77,000.
Now he
No,
has
you
lost
know,
his job.
When did he lose the job?
18th March 2025 is the last working day, my lord. He was on a notice period from December. He was asked to terminate the services, but he.
Did you file all those documents?
Lord, after the order is passed, this situation has arisen, my lord. I have filed it along with this. I have this, Lord. I see that I want to place it on record. I'll place it on record, my lord.
Please place it on record so that they'll get an opportunity.
Very well, very well.
No. What she says is, during pendency of this petition or before filing of this petition, and after the orders were passed, he lost the job. She wants to place it on record. Any objections you have to that, you can file.
Daughter has just passed SLC. She has to be admitted to college for.
Was there any stay? Stay order is there, my lord, but he's paid the school fees. But there should be a conditional order. How can the entire the order be stayed? My lord, he is paying the educational fees. Even now, he has paid the fees for the first child, my lord. Second child, he has autism. And for that special school, he is ready to provide for the child's education also. And considering. No, shall I record that the respondent will take care of the educational, the petitioner will take care of the educational expenses of the children? Very well, my lord. Very well, my lord.
Children have to be admitted to the PUC, you know.
No, that's what she's saying there. She's saying that he's ready. That I'll record. He has paid the first installment for the daughter.
Only a submission is made to that effect even at the time of petition.
No, then in that case, there should be something on record. You should be able to tell that this is the school we are going to admit. These are the amounts that are required. Then the court will say you pay it. Then ascertain all that. We'll have it on Wednesday. Let's just matter on Wednesday at the request of the counsel for the respondent.
Cell number 48, Chandrasekhar K. 48, Chandrasekhar
No
K.
representation. Let's just matter of 2 weeks.
Cell number 49, preliminary hearing B group, Suma.
Counsel for the petitioner.
Krishna,
I
yes.
humbly beg before this honorable court for 2 weeks' time.
Just after 2 weeks at the request of learned counsel for the petitioner is 50.
Cell number 50,
Much obliged.
Eugene Prabhu.
Yes, at the request of learned counsel the respondent 3 weeks.
51, 50.
I'm not able to understand or not even one word.
Petition copy is also not furnished.
Now, to whom we have to say? Yes.
Cell number 51, 52 adjourned. Cell number 53, Ravindra V. Reddy.
Lordship, I am proxy counsel. The senior father is not well. He's hospitalized.
Yes, after 3 weeks. 54.
Cell number 54.
No representation after 4 weeks.
54.
Yes.
Look, this is a matter relating to visitation rights of the children. Lots, though we've challenged annexure A, my lords, the difficulty is, my lords, even the visitation rights which she has admitted, my lords, which is not being challenged, the mother is not allowing the father to see the children.
But
he says
for that
they have filed 2 execution petitions. Here, my lords, what he's asking, my lords, he stays in Chitradurga, so he's asking for the custody of the children during the weekends, not just on kindly see page 34, my lords. 34, my lords. The order is permitted to meet the minor children on first Saturday of every month between 4 to 5 p.m. on mediation center. Lords, every time she does not bring the children to the mediation center.
Then that we will not
that
decide.
is not for that. Not for that.
Modification
We have asked, my lords, during the weekend, if he has the custody of the children for 2 days, my lords, he can have little.
What is the age of the children?
The children, one was 13 and one is 8. Now they must be 14, 16 and 11 years.
16 and
11. The daughter is 11.
So we don't know what is the relation and how comfortable the children are for a weekend custody.
My lords, your lordships can direct them to. They do not even come.
That's what. No, the
not
notice
even
is
once before
no,
your
vakalat
lordships.
is fine.
My lords?
No vakalat is fine.
It's fine. They don't come.
Who is appearing?
Only served.
Nobody comes.
No vakalat. Where is the vakalat? There is no vakalat.
Oh, there's no vakalat.
It's served unrepresented.
Unrepresented. They don't even bother, my lords. Right from the family court to the execution court, they don't come. She doesn't bring the children. The father, my lords, it's almost like his right to see the children. He says, I haven't seen the children from so many years.
I think the remedy for you is to get orders in the execution petition.
They've done that. In spite of repeated orders, she doesn't come. Your lordships
kind of cases without interaction with the children, we cannot pass any order.
Could your lordships grant me one more occasion, my lords, to serve this notice upon the council
The
again?
petition is permitted to serve the council appearing for the respondent before the transport and shall file a memo to that effect by
next week, my lords?
By 12th of June.
Yes, please.
Yes, next. Hands up. Yes,
Great.
55.
Serial number 55. G.S. Venkat Subbarao. K.V. Narasimhan for respondent.
Yes, what is this?
My lord, we moved the matter. My lord, it pertains to perjury matter, my lord, where she has filed affidavit, wrong affidavit before the trial court. May be taken up tomorrow, my lord. That unnecessarily they are taking date.
For representation for the petitioner, list this matter for dismissal on Tuesday.
Obliged.
This 56.
Serial number 56. Ramesh. H.E.
For the petitioner in this case. In this case, madam, there was a joint affidavit was filed by the both the parties, madam. After that, madam, there is no, not even a single pie has been paid by the respondent.
Give the file.
56. At page number 54, madam, joint memo was filed by the both the parties assigned together. The counsel for the petitioner and respondent in the above hereby withdraw the petition as both the petitioners and respondents are living together. Hence, the petition may be withdrawn as not present. Hence, this memo in the interest of justice and equity. After that, my lord, no, he has not taken back from the petition.
Taken?
No, after 1 week, my lord, she has again thrown out from the matrimonial house. Respondent. Now, after that, my lord, sir, he did not pay anything.
Regarding the maintainability, your lordship may kindly see, it came to be withdrawn. He cannot find fault with the order passed by the Lok Adalat. She herself withdrawn the petition. That is the first submission. Second submission is, till last year, she was with the respondent.
Oh, it's a new cause of action.
New
for
cause
you.
of action.
Go and file before the court. Now, because it's your case that you are staying together, you withdrawn the case.
No, because
or you, whatever it is. Now, it's a fresh cause of action for you. That again, the husband is not staying with you, or you deserted him, whatever it is. You can file a fresh petition. Why this has to be? It's not that you have no other remedy.
The only thing is, my lord, because after the withdrawal of the petition, only 1 week she has stayed with the respondent. After that, my lord,
Okay, that you can't. Will give you liberty. Will give you liberty to pursue the remedies available to you against the husband. Please come.
the thing is, my lord, reserving liberty to file a fresh.
That's what I'm saying.
Yes.
The present writ petition is filed seeking the following prayers. Then counsel for the petitioner submits that. Extract this prayer portion. Then counsel appearing for the petitioner submits that after the withdrawal of the petition.
I make one submission. If there is a possibility of settlement is concerned, my lord, let them know.
That both of you can work out.
But
refer it to the Lok Adalat. I mean, to the mediation center.
But your lordship may kindly see, both of them are in Dodbalapura. Let them file a petition there. Let them settle it if they want.
Thing is, my lord, why? Because it's a matrimonial is concerned, matrimonial case is concerned, my lord. Last occasion they have called.
Is there a mediation center there?
Yes.
There
no,
or not there?
No, Bangalore is the way best one.
Then how can they come
No,
all the way?
Dodbalapura is also. They are residing in Bangalore only, but married at
both the
Dodbalapura.
parties shall appear before the Bangalore Mediation Center on 19th of June.
At 3 p.m. Let's see.
3 p.m. Yes.
Serial number 57 urgent. 58. Yes, Venkat Subbarao.
Krishna. Lord, in another matter, Lord, I apologize, Lord. I was on my legs, my Lord. I could not reach the court. Item 55. 55 is also mine, my Lord.
Where is he? The council. Then list this matter tomorrow. Not dismissal tomorrow. Then what about this 58?
Well, this, my Lord, is my Lord,
you have an interim order.
Please.
No representation for the respondents. Counsel for the petition is present. List this matter after 4 weeks. Interim order earlier granted is extended.
Great.
Next.
List number serial number 59 disposed. List number 2 parted matter. Serial number 1.
My Lord, this may kindly be called on Tuesday, my Lord.
Every
Am I
time
audible,
you
my lord?
ask for adjournments, Mr. Umesh. Every time the
My
matter
lord,
specific to ask for adjournment.
Tuesday, my lord, I am only sitting, my lord, myself, my family, everybody is
From
ill, my
Parter,
lord.
delete this matter from
Tuesday,
Parter, pose before the regular court. The
Cell
next,
number 2, P. Mahesha.
This matter, I believe TCR will be needed, my lords, because the injuries are grievous in nature.
delete from Parter, this before the court having the.
Cell
having
number
roster.
3.
I'm
Next
obliged,
thing.
my lords.
Cell number
This case
3.
is settled for globally 2 lakhs, my lord, earlier. And
For respondent, on behalf of B. Pradeep, I am representing. my lord.
Mm.
Globally, we have last Lokada, we have discussed 2 lakh rupees, but Reliance company has been not agreed. Sriram,
They are not accepting.
they have not accepted, my lord. Sriram General Insurance Company, they have agreed for 2 lakh
Will
rupees.
pass an order.
they want
Judicial order may
order,
be
my lord.
passed, my lord.
Give that.
Contributory negligence, both the insurance company have
60-40 is there.
60-40.
That will be confirmed.
Please, my lords.
Para number 106, page number 106 of the
What
judgment.
was granted by the court?
Court granted, my lord, 7,56,508, my lord. 508, my lord.
7 lakh
56,508.
508.
Yes, my lord.
Now another 2 lakhs.
Yes, my lord. The
How-
minor, my
Under
she-
what heads it can be?
my lord, it's globally, my lord. She is minor, my lord, 10 years girl. Hence, court has stated that 2 lakhs it may be granted.
Oh, that was
That matter,
Pradeep
madam.
must have said.
Pradeep also is there, madam. That matter.
No, but now if I have to pass an order on the merits of it, then there has to be some reasoning. That's a problem.
Yes, madam.
I can't do it globally without giving a reason. Delete from Parter, pose before the usual court having roster.
Cell number
Yes,
4.
Much
4. Keshavamurthy B.
Appear for the appellant, my lord. It is a case of injury, my lord.
Mm.
My lord, the accident was taken place on 27/9/2014.
Mm.
My lord, this appellant was working as a IT analyst, and earning
Then
40.
the respondent counsel is not there. Delete from the caption Parter and list this matter before the court having roster.
Cell number
Then
5.
Appellant.
Cell number 5.
Same order in this also 5.
Cell
And
number
6.
6. Vijay Kumara.
6 also same.
Cell number 7.
What, you have any instructions in this?
My lord, last time argument has been done, dictation pending for dictation.
Oh, dictation is
Please,
easy.
my lord.
dictation.
Give that. Give the 5.
7 ಅಲ್ಲ?
6 serial number 6.
6.
77457746.
What are these 2 petitions?
Both are sisters, my lord.
Then the calculation appears to be only in one petition.
No, my lord, it has been filed
MFA
separately.
7745.
Yes,
What
ma'am.
about 46?
46, no.
Take the other file. No, you have to see the front side. It is not there. Calculation appears to be only in one.
There is common judgment, my lord.
ಅಲ್ಲ ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಿರೋದು
That has been
There are
20,000 has been allotted to.
I think that I was not interfering then.
Yes, my lord. Here, my lord, 7746, 2
No.
lakhs something.
No, please understand. In MFA, in one MFA, there is one MFA 7745.
Yes,
There is calculation.
Yes.
6,93,841 is granted.
Yes, ma'am.
That will dictate the order.
Yes,
The
ma'am.
other 2 will confirm it.
Yes, ma'am.
Other appeal.
Yes, ma'am.
Please come. Agreed with the order passed in MFA 7745 of 2016, dated 2nd September 2016. The claimant is before this. What is the MVC number?
MVC number
774, sorry.
6768 up to 2013. 7746. 6768.
Of 2013, the claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 12 lakhs for for the injury sustained by the claimant in the accident. The tribunal had granted compensation of an amount of rupees 5,45,000
521.
521. Land counsel appearing for the petitioner submits that the tribunal has not granted a just and reasonable compensation. It is submitted that he had sustained 4 grievous injuries and the amount that is granted under the head of pain and suffering is not a reasonable compensation. It is further submitted that the court had considered the income at
2013 accident.
court has considered what? Both of you should be ready with the figures. The court had taken income at rupees 7,000. Land counsel submits that's an accident of 2013. The court ought to have taken 8,000 as compensation. As far as the medical bills are concerned, there is no dispute about that. When it comes to loss of future in earning, the court had granted
7,000. Come take.
the court considering 8,000 to 7,000 as income. 7,000 as income and considering the disability at 23% had granted an amount of rupees 1,10,880. Land counsel submits that the Land counsel appearing for the respondent submits that the disability, 1/3 of what has been decided by the court, would come to 20%, but not 23%. Then coming to the loss of amenities, court had granted only 20,000, which is not of the which is not a just and reasonable compensation. Towards future medical expenses, court had granted only 15,000. Next paragraph. Then counsel for the respondent insurance company submits that the court had granted a just and reasonable compensation. No enhancement is called for. Next paragraph. Having had the counsels on either side peruse the material on record. Considering the 4 grievous injuries that are sustained by the claimant, this court is granted an amount of rupees 60,000 under the head of pain and suffering. Coming to the loss of earning during the later period, court had considered 7,000 as income and this court is taking 8,000. 8,000 into 3, 24,000. Towards medical bills, court had rightly granted the compensation. No interference is called for. Then coming to the loss of income, considering the disability, this court is taking the disability at 20%. That is 8,000 into 12 into 11 into 20 by 100 is 2,11,200. Coming to the loss of amenities, considering the disability, this court is granting 30,000. Transport, nourishment, court had rightly granted 20,000 and no interference is called for. Future medical expenses, this court is granting 20,000. Altogether, the claimant is entitled for an amount of rupees 7,03,841. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 5,45,521 to 7,03,841. Next matter.
Please, ma'am. Macham.
Next matter.
Globally awarded maladies.
Yes, that we will confirm.
Please, ma'am.
MFA number 7746 is against arising out of MVC number?
MVC number 6765.
6765. The present appeal is filed, agreed by the award passed in so and so. dated 2nd September 2016, whereby the tribunal had granted an amount, globally an amount of rupees. Where do you get that?
Judgment page number, my lords, judgment page number 37.
30?
7. Running page number 49.
49.
Please, my lord.
Not 49. Internal page?
Internal page 37.
No. Where is the discussion? You're talking about the penultimate paragraph.
There is no discussion, but they have mentioned.
It must be there in the, what is the MBCS there? 6765?
67, 66.
Six seven? 6768. Not correct. That is also not correct what you are saying there. This is arising out of 6768. But 6768.
6768 5,45,000 my lordship has been declared the judgment. 6766 MVC number.
Wrong file you have given. That's why it is showing it as
6766 for 30.
next is 6766.
Please, my lord.
6766 is 40,000.
40,000 awarded.
6766. It is correct. 6766. What we do is, he had sustained three injuries, 30,000. And which year is the accident?
2013, my lord.
40,000 is sufficient. Agreed with the award passed in MVC number 6766 of 2013, date so and so. The claimant is before this court seeking enhancement of the compensation. The claimant had sustained lacerated wound over the left front, tenderness over the left hip joint, parietal region, tenderness over the low back. And the court had granted global compensation of rupees 40,000. Then counsel appearing for this, the appellant submits that the court ought to have granted a just and reasonable compensation. The compensation that is awarded by the tribunal is not reasonable. This court has perused the order passed by the court, award passed by the trial court, and also the injuries sustained by the claimant. The tribunal had directly granted 40,000 as global compensation. This court finds no reasons to interfere. Next.
Much obliged.
What about 7? Delete from the part heard and post before the court having roster. 8.
Respondents 8 to 6.
Yes.
It's 1 8 to 6. Short accommodation in the matter.
Is this also delete from part heard and post before the regular court? 9.
For the appointment, these are for the enhancement of the compensation. Insurance is admitted, madam.
Look at it. Any calculation is made? 9. No calculation. Yes, delete. Post before the court having roster. Yes, 10.
Cell number 10.
Look at it. If there is any calculation, we'll pass order.
What about 9?
10, no calculation.
Yes.
9.
Delete from part heard. Next 11.
Number 11. Sri Harsha AK.
Any calculation is done in this?
No.
Please, my lord.
Calculation is made
No,
on
no, ma'am.
delete. Yes, 12.
Cell number 12. 12. Banu Prakash.
Calculation is done.
No, my lord.
Delete.
Cell number 13. N. Kumar.
Same.
Also no calculation.
14.
Cell number 14.
Same.
V. Palakshaya.
Same.
Cell number
One submission, serial number 14. That's it is appealed by the KSRTC. That's the corporation has requested me to appear in this case. My name may be my lord's order to be shown in the cause list.
So and so, the registry is directed to show the name of so and so.
14.
14.
Grateful.
Yes, Rajesh.
Yes. 15.
Cell number 15.
Same order.
Release from partner. Cell number 16.
Yes.
Syed Abdul Sabur.
17.
Cell number 17.
Same order.
18. Sripad V. Shastri.
Same order.
Cell number 19.
Yes, Mr. Venugoda. Any order can be passed.
Calculation, it can be simple injury, my lord, facial injury.
Where is the counsel?
But they have not appeared.
Then we'll have it tomorrow, 19.
19.
Ask him to come.
Yes.
No representation for the appellant. Counsel for the respondent is present. Yes.
Cell number 20. Adjourned. Cell number 21. PB Sidramaya. Maintainable.
Delete from part third. Yes, 12, 22.
Cell number 21.
Not 21, 22.
2. N. Gautam Raghunath.
Yes.
For settlement.
My lords, kindly pass over. Senior might be coming.
One
She
second,
hasn't.
this is not that matter.
22, right? Yes.
Sorry.
What's happening in this?
I don't think anything can materialize because, my lords, what's happened is basically what visitation rights were granted are not being complied. Your lordship says meet the son, have the son with you for 7 days. They send only for 2 days. But it's reached a point wherein it's very unfortunate that all your lordship's efforts could not materialize.
Delete from part third. Post in the usual.
Let the regular visitation rights continue, my lord, what is granted.
Oh, no, I'm just saying let it continue on whatever the
Earlier arrangement may be continued.
The earlier arrangement with regard to the visitation shall continue.
Cell number
Yes, 23.
23.
Great.
Ananya Rai.
23 also delete from part third.
Cell number 24. PB Appaya.
I appear for the petitioner in this matter, my lords. Let the visitation rights continue. The visitation rights as per my lord's order 25/9/2024 is 1 p.m. to 5 p.m. Let that continue, my lords, may be deleted.
The delete from part third and the earlier arrangement with regard to the visitation shall continue.
The Nimhan's report has also been placed on record, I believe, my lords, as per the cost date. Great.
Yes, next.
My lords, the earlier order may continue, my lords, the visitation
That's
rights.
what I said.
Grateful, my lords.
Yes, 25.
Cell number 25.
Appear for petitioner, my lord. Kindly fix the next date, my lord. Next week.
Delete from part third. Rest is matter after service of notice to respondent.
Cell number 26.
This appear for the,
Jal.
this matter is to be directed for posted on 9th. I don't know why it's posted today.
It's posted because it is part third.
Because
This
my
is
client is coming on
delete from
9th and
delete from part third and post in the usual course.
Yes. Cell number
Whenever
27.
these petitions are there, don't write before the other petition because we are having the roster. Only MFS before the court having roster. 27.
27.
This
Cell number
also delete from part third.
One submission, madam. In serial number 45, madam, the notice has been ordered, madam. But there is one application, application, madam, for stay is pending, madam. That may be
24 matter. What has not happened in 24? No urgency for that. No files.
serial number 45, madam. Serial number
It won't be. 24 matter. What is IA now?
IA for
Once
stay.
the notice is served, we will see. We have waited for a year.
Serial number.
My lord, if I make a submission, I wanted to submit a memo for service of order by hand, my lord. In WP 358 of 24, an order was passed by this honorable bench. Since it's a time-sensitive matter and we had to challenge the same said order, we may be permitted to collect the order today, my lord.
How can it be? How can the order be ready by today itself?
But it's time-sensitive, my lord. It's a request.
It will come.
Extremely sorry to interrupt. Serial number 54. My lord, I have filed this petition. I am the petitioner here. I have not seen my children from past 8 years, my lord. Kindly grant.
So already your advocate has appeared.
My lord, but I want some directions from this court.
That for that you are represented by an advocate. How can you represent?
I'm not representing, I'm requesting to
Represent, request anything by your advocate, not by you. Yes.
Number 27 in the second list, my lord. I'm for the petitioner, my lord, and both were having some inconsistency on Monday.
It's already over.
It's parted. Monday, my lord.
No, it is deleted from parted.
Release from part.
Deleted from parted. It will come before the usual court. Yes, Renuka, you are not there in all the matters.
Sorry,
No, if any matter you are ready, we'll keep it because none of the advocates are there. But wherever there is no calculation,
One matter could be because that's a case where there was a delay of 10 years in filing the claim petition.
whichever is that matter listed on Monday.
On submission, my lord. Serial number 25. Fix the date.
Yes, they will. Once the notice is served, notice has to go.
Can it be tomorrow?
Yes.
My lord, can it be recorded that I've tried to move this memo in case there's a delay in uploading of the order? We can state that we tried.
What do you think? What is this? Who is instructing you to this kind of representations to be made? First of all, your senior doesn't know what to say, and he is telling you something which is very inappropriate. That I should record that they wanted to move a memo for the hand delivery, and then I said it is not possible.
Not that it's not possible, my lord.
Then what I should record?
That I've moved a memo.
And if you want to appeal against that order, and the court has to do it right when the order is passed, and by evening I should give you the copy of it. There should be some reasonableness in making requests.
Please, my lord.
Serial number.
573. 397 ಇದೆ. serial 3
ಇವತ್ತಿದೆಯಾ ಮೇಡಮ್?
5733 serial number 8. 5733 ನಂದು 397.
ಹೌದು. ಇದೇನ್ ಮಾಡ್ಬೇಕಿದು? ನಾಳೆ
ಮೇಡಮ್ ಮಾತ್ರ
ಏನು ಮಾತ್ರ
Number 8.
ಮೇಡಮ್ 21.
ನಾವೇ ಬರ್ಕೋತೀವಿ ಬಿಡು. ಏನೇ
ನಮಗೆ ಕೊಡಿ, ನಾವೇ ಸುಮ್ಮನೆ ಇದೇನಾಯ್ತು ಮೇಡಮ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 7 ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಏನಾಯ್ತು ಹೇಳ?
6 ಅಲ್ಲಿ ಕನೆಕ್ಟೆಡ್
Globally ಇದು
ಕನ್ಫರ್ಮ್ ಆಯ್ತು ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ಡ್ ಇದು
ಇನ್ನೊಂದು ಪಾರ್ಟ್ಲಿ ಅಲ್ಲ.
ಬಾಕಿ ನಾನು ಹೇಳ್ತೀನಿ.
ಡಿಸ್ಮಿಸ್ಡ್ 7 ರಿಲೀಸ್ ಫ್ರಮ್ ಪಾರ್ಟ್
ಮೇಡಮ್ 21 ಮೇಡಮ್ 6 ಗೆ 9 ಡಿಲೀಟ್
ಎಲ್ಲ ಡಿಲೀಟ್ ಒಂದೇ ಒಂದು ಮಾತ್ರ
ಡಿಲೀಟ್
19 ಮಾತ್ರ
ಆಕ್ಚುಲಿ ಡಿಲೀಟ್ ಫ್ರಮ್
ಅದೇ ರಿಟ್ ಪಿಟಿಷನ್ ಮಾತ್ರ ಹಾಕ್ಬಿಡಿ ಅಂತ ಅಂದಿದ್ದಾರೆ ಮೇಡಮ್.
ಹೌದು ಎಫ್ಸಿ ಮ್ಯಾಟರ್
ಮತ್ತೆ ಯಾವ ತರ ಹಾಕೋದು ಮೇಡಮ್?
ಅದಕ್ಕೆ ಅದೇ ರೋಸ್ಟರ್ ಬೇಕು
ಮೇಡಮ್ 21
ಮೇಡಮ್ ರೋಸ್ಟರ್ ಇಸ್ ವಿತ್ us only in usual goods
21
ಮೇಡಮ್ 59 ನೋಡಿ ಮೇಡಮ್.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 21 ಮೇಡಮ್. ಇದೊಂದು ಯಾವ್ದೋ 4 ವೀಕ್ ಅಂದ್ರು ಅದನ್ನ ಸೆಲ್ ನಂಬರ್ 8 ಒಂದು ಇರೋ
ನಾಳೆ ಒಂದು ಡೇಟ್ ಇರುತ್ತೆ.
59 ಡಿಸ್ಕಸ್ as withdrawn ಅವರು ವಿಡ್ರಾನ್ ಮಾಡಿದ್ರು.
8 ಅಲ್ಲೇ ಹೊರಟೋಗಿದೆ ಬಿಂದು 8 ಆ ಕಡೆ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ಯಾ ಫೈಲ್? ಅದೊಂದು ವಾಪಸ್ ಕೊಡಿ ಹೇಳಿ ಸರ್. ನಮಗೆ ಗೊತ್ತೇ ಇಲ್ಲ, ಇನ್ನು ನೋಟಿಫಿಕೇಶನ್ ಬಂದಿಲ್ಲ.
ಮೇಡಮ್ ಇದೊಂದು ಕೇಸ್ ಲಾಸ್ಟ್ 2/5 ಗೆ ಲಿಸ್ಟ್ ಆಗಿತ್ತು, ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು ಸಾಹೇಬರು ಮೇಡಮ್. ಆ 2/5 ಗೆ ಕಂಪ್ಲೈನ್ಸ್ ಕೊಟ್ಟಿದ್ರು, ಬಟ್ ನಾವು ಕಂಪ್ಲೈ ಅವಾಗ ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ.